Check 1 2. Hello, hello. This is going to be Just Human episode 354. I'm getting this one out later than I wanted to, a couple days later. I've already done some recording for it, and that's going to be that's probably the portion of this episode I'm most excited about is already recorded. And I wanted to release it on Friday, if not Friday, Saturday, but I ended up getting cluster headaches for the first time in quite a while, which is a good thing. I used to get them a lot more regularly, especially last year. I was getting them very regularly. It ended up being a big problem for me. But this year I've been pretty good. And but this week, I guess weather changes and seasonal allergies and stresses, I just kind of got hit with them on probably starting Thursday, and then was really bad on Friday and Saturday. So that's when I got the glasses back on. I've used these before. I tend to use these when I'm driving at night. And then also whenever I'm having kind of a migraine or sinus headache type sensitivity issue, these glasses tend to help me. And since I'm going to be sitting here in front of this screen, reading court documents, all this light coming at me, this is going to make it easier. So episode's a bit later than I want it to be, but the content of it is, well, I shouldn't brag too much, but we have some really exciting things happening. And there's been some big developments in the Comey case, which we're going to cover. And then there's also this new email chain that Chuck Grassley got that concerns a DOJ attorney and an attorney in the USDC's attorney's office icing an investigation that a FBI agent was trying to open into the Clinton campaign and the DNC and their payment through Fusion GPS through Perkins Coie to Fusion GPS for the Steele Dossier. It was an investigation into the funding of the Steele Dossier. That's what it was. And these two attorneys iced it. And the email chain is really interesting. It's got some revelations in it, but it's also highly entertaining because there's an FBI agent who isn't taking no for an answer and was very clever in his responses to these attorneys, and then clever in the actions that he took to preserve this record of an investigation that almost was. So it's a disclosure yet again from Chuck Grassley, who has been very good about conducting oversight of the FBI and DOJ and going after documents that are quite good for oversight, but quite telling for us who are trying to keep up with the greater story of Russiagate and Spygate and all of these things, Hunter Biden, the Biden crime family, all of these things that regardless of what you think, what you make of them and the conflicting narratives that come out about them, I love that he goes and gets the documents because the documents allow us to see the evidence for ourselves. So I already have that segment recorded, and I'm really pleased with it and excited to present it to you. I presented a shorter version of it a couple days ago. It's this video right here: DOJ and DC attorney iced FBI investigation into Steele Dossier and Hillary campaign payment for the Steele Dossier. So this is a shorter version of it, it's 20 minutes long. I was quite pleased with myself that I nailed it right at 20 minutes. So I released that on my Rumble page and on my YouTube page, and I've released 3 videos but since my last full Just Human podcast episode. So if you keep checking my Rumble and my YouTube, you'll get these shorter versions of episodes. I'm trying to nail between 15 and 30-minute presentations. So I did one on 4 Antifa groups that are based out of Europe being designated as foreign terrorist organizations, the one on the email chain, and then one right here, which I gotta say, guys, I kind of did a clickbait title. I did, and I'm kind of embarrassed about it. Comey's prosecution at risk over Halligan's appointment could be dismissed by Thanksgiving. It's a bit of a clickbait title. It's not untrue. It's totally true. But I tried like 3 different titles for it, and that was the one that conveyed the 2 messages that I wanted to convey in a title. There's a risk to it, and by Thanksgiving, we're going to get an answer. So that's the subject matter I want to get to initially, is a Comey update. That's where we're going to go first. So welcome. Thank you for being here. Over on my profile or in the description of wherever you're listening or watching this, you'll find my link tree. And on my link tree, you can find all the places to follow, all the places to watch, all the places to listen, and all the ways to support the show. I've recently added a link to my threads. So even if you're not on X because you're banned or you just don't like X, I've been doing lots of threads over there, or more threads. Maybe not lots, but I've been doing threads more frequently. And you can get them here and keep track of them here. And I tend to share them out on True Social and on my Telegram. So that's another way you can access them. But I thought it might be good to just go ahead and put a link to all of my threads right there. Thank you to everybody who's been going over to YouTube and leaving comments, liking the video. I really appreciate that. That helps me a lot on YouTube. That counts for a lot when you like a video and when you comment. Even if you just want to comment, Comey's my homie, or you want to comment, Kyle, you're totally wrong about Comey. He's a no good, very bad guy. He's a dirty cop. It's great. It doesn't matter. The way it works is that if you leave any kind of comment, even if it's just to say hi, there's this one guy, Biscuits, who's like always commenting, "What's up?" That's like all he says, "What's up?" Or if you want to write me a long, detailed thought or your take on something that I've presented in the show, agree or disagree, I appreciate all of it. So, and I had some really nice comments come in recently, and thank you guys. Those hit home. I'll say that. If you want to support the show, Benson Honey Farms is a great place to go. You can use my affiliate link and get yourself some all natural, 100% raw honey. It's delicious. It's some of the best honey you can have. I like honey a lot. And I buy local honey because it helps with allergies. And then I also get Benson's honey. And Benson's honey is a brighter flavor of a honey. Some honey is very floral, or it has a very dark, rich sweetness to it. Benson honey has a light sweetness and light and bright sweetness to it, is how I would describe it. It's very, very good in tea or on waffles. That's how I like to use it. They also have homemade goat milk soap that is very, very nice. If you feel like pampering yourself, hey, it's okay. It's nice to have nice skin, right? And their soap is excellent for that. Bootleg Products is another link. If you use my affiliate link on either one of those, they'll kick a few dollars my way out of your purchase. Bootleg Products, they have excellent seasoning, salsa, and it's chili season. It's getting cold out there. Their chili is delicious. Absolutely delicious. And their seasonings are good. Their taco seasonings I use on a bunch of different things, not just tacos. If you just want to buy me a cup of coffee, though, you can go to ko-fi.com and just keep me caffeinated. It does require a lot of caffeine. Yeah, a lot of caffeine is required in order for me to read all these documents. And so if you keep my coffee cup full, you will contribute to me staying caffeinated. And justhuman.substack.com. That is the core of my support. You guys who buy a $7 a month subscription, or if you get one that's a yearly subscription, that's you guys are just awesome. And I can't thank you enough to all of you who do that. $7 a month is a cup of coffee plus the purchase of a few documents over on Pacer. So cheers. Thank you very much. Okay. Comey docket. I already made one run at this, doing an update on this. On Friday, I recorded it, I think it was, and I just wasn't happy to it. Like I said, I had a headache coming on, and I took some meds to try and counteract that. And then I made a pot of coffee, and I just felt like I wasn't as put together as I would like to be. And I recorded about 30-minute presentation, and I ended up just, nah, I'm gonna rest all day Saturday and try to do this on Sunday. And here I am. So let's hope that this pass is better than the first one. All right. So what I want to do is I want to catch you up to the moment before this hearing. So if you already read my thread on this, and even if you already watched my video on Comey's prosecution being at risk, don't worry, because this is where we're going to get into the details, and I'm going to give you a bit more information and also give you the story of what's going on here, so that you're not falling for any half-assed reporting or any rage baiting that's going on out there, any fake news. Let's get the real story. So the hearing's coming up on 11/10, and as they're getting ready for that hearing, both sides make filings ahead of that hearing to brief the judge one more time. And if you recall, they already met with Fitzpatrick one time. Well, actually, let me back up just a little bit, because not everybody knows this, and this case is getting complicated a little bit. There's kind of 3 tracks in this case because there's 3 judges, okay? There's Judge Nachmanov, he's the criminal judge, the district judge who's handling the criminal case. And he's the one who's going to handle all the filings they have to do with trial proceedings and the trial itself. That's Judge Nachmanov. He's Eastern District of Virginia district judge. Because Comey filed a motion to dismiss based on Lindsey Halligan's unlawful appointment, the rules are that an out-of-district judge has to hear that challenge, because it's a challenge against the attorney who is there working in the Eastern District. So the judge who got brought in is Judge Currie, and she's a senior judge out of South Carolina. And so she is handling only the proceedings they have to do with the lawfulness of Lindsey Halligan's appointment. The other judge is Judge Fitzpatrick. And Judge Fitzpatrick was brought in because DOJ wants a filter team. Filter teams are used when there's some sort of material that there's a privilege over, or there's something about it where it may not be lawful for the prosecution to get it. There's some question over the material. And so a filter team is brought in as a third party who is going to go through that material and separate what is privileged and what is not. And what's not privileged, what the evidence or the material, whatever it is, that is, there's no legal question over, that then goes to the prosecution, and then it gets turned over in discovery to defense. But where there is material that is legally questionable for some reason, such as material that was seized from an attorney and its communications between the attorney and the defendant, which is what is going on here, that's attorney-client privilege material, and it's protected. And the prosecution can't have that. They can't use it. They can't even see it because it's shielded by attorney-client privilege. However, there are exceptions to attorney-client privilege, such as crime or fraud, where there's something going on in those communications where the subject of them doesn't have to do with legal counsel. It has to do with something criminal or potentially criminal. And when that occurs, that filter team can take that material, present it to a judge, and the judge looks at it and he decides whether or not the attorney-client privilege can be pierced, is what it's called. It can be removed. And if that happens, it can go into the evidence bin for the prosecution and then get turned over to defense and discovery. Okay? So we already had one hearing in front of Magistrate Judge Fitzpatrick, who's, again, only handling the issues that has to do with the filter team. DOJ wants this filter team for a set of evidence that was seized during the Arctic Haze media leak investigations. Those investigations ran from about 2017 to 2021, and they concerned leaks of either classified or unclassified but not authorized for disclosure information that was turned over to media outlets such as New York Times, Wall Street Journal, Washington Post. And those leaks led to a characterization of the Russiagate scandal, of the Clinton investigations, either her email server or the foundation investigations. And they generated fake news and generated narratives, and they were unauthorized leaks. Some of them were very, very highly classified, such as the Renteria memo and the information about the Clinton plan to tie Trump to Russia in order to distract from her email server scandal. Somehow that got out. Now, we know that at least one of the leakers of information was Deputy FBI Director Andy McCabe. He got caught. He lied about it multiple times, but eventually he got caught. And he got caught because IG Horowitz was able to get Lisa Page's text messages between her and McCabe and her and Peter Strzok. You know, the media on the right kind of made a big thing about the Page-Strzok text and drawn attention to them being the lovebirds, as Trump called them, and their animosity towards Trump. That's not really the story of those text messages. The story of those text messages is, one, them trying to figure out how the New York Times already had classified information. It leaked from somebody. And then two, Lisa Page working to get into McCabe's office. She wanted the promotion and she wanted to work there. And then McCabe using her for his leaks to the Wall Street Journal back in October of 2016. So because of all those leaks that were happening, the FBI under Comey and then later under Wray launched these media leak investigations to try and figure out who at FBI or DOJ was giving this information to the media. At the same time these leaks were going on, Adam Schiff was also leaking from the House Permanent Select Committee on Intelligence. Remember, we read about that several months ago, thanks to some disclosures. They were sending staffers over to the CIA to look at classified information. Then they would rush back to a specific computer at the House and they would type up these reports. And then the media would call that afternoon for their leaks from the House. That's another one of the investigations that was going on. And together, they were shaping news coverage and they were affecting these investigations in a detrimental way. So one of the media leak investigations was Arctic Haze. And that one ended up, through the course of that investigation, they ended up getting 4 search warrants for Daniel Richman, who is person 3 in the Comey case. And Daniel Richman was a special government employee for the FBI. He was like a not a liaison, but a consultant to the FBI. He's a legal scholar. He's a former SDNY prosecutor. He helped prosecute the mob in the 80s. If you know, you know. And yep, he worked with Giuliani. If you know, you know. So he and Comey are good friends. And Comey ends up communicating with him about some things, sending some memos to him after he got fired. Arctic Haze investigators took out 4 search warrants for Daniel Richman's devices: his iPad, his iPhone, I think a computer, and his iCloud account, maybe an email account. And through those, they got some materials. Durham looked at them. The investigators out of the Washington field office looked at them. And DOJ looked at them. And ultimately, they decided not to bring charges against anybody. In fact, their declination memo, stated something to the effect of, the evidence we have over the course of years of investigating doesn't present enough evidence to charge Comey or Richmond or anyone else for leaks to the media. So they weren't able to rise to the level of bringing charges against anybody. And the investigation ended up being closed because there were no more leads to pursue. They'd worked it as far as they could work it. Now this case comes about, and Comey's accused in the indictment of authorizing Daniel Richman to leak information to media about the Clinton investigation anonymously. Now, we know for a fact that there were times that Comey authorized Daniel Richman to speak to the media as a named source. And we know that Daniel Richmond did speak to the media as a named source. That's not the lie, the alleged lie. The alleged false statement, the 1001 charge that Comey has been hit with, and then the obstruction charge that comes after it, is based on an allegation that he authorized Daniel Richmond to leak to the media anonymously about the Clinton investigation. Comey said he never did that. He never authorized anybody at the FBI to leak anonymously. So prosecutors in this case, naturally, since there's already been an investigation into Comey and Richmond for this very thing, go back to the Arctic Haze file cabinets and pull out the evidence from there. And October 13th was the due date for discovery to be turned over to defense. In this case, it's Rule 16 evidence, which is evidence that the government has against you. They give Comey 85,000 pages of discovery, but they hold back a small portion of it because they realize at some point, don't know when they realized this, but they realized it by October 13th that some of this stuff was attorney-client privileged. And so they need a filter team. So due date comes for turnover of discovery, Rule 16 discovery anyway. October 13th rolls around. They give Comey 85,000 pages, but they don't give him this set because they need a filter team. So they file a motion with the judge asking for a filter team to be approved so they can deal with this material. 7 days, well, per the rules of this district, the defense has 2 weeks to respond to a motion of that nature. 7 days go by. Prosecution goes back to the judge and says, please, please, please expedite a ruling on this filter team stuff. We need a filter team to go over this evidence. And the judge says, I can't go ahead and order a filter team because the defense hasn't replied and they have 7 days to do so. I have to wait for their reply. So defense files and defense says, we're not completely against a filter team, but we want to challenge the underlying search warrants that they acquired this information with. And by the way, we have reason to believe that some of this attorney-client privilege material may have already leaked to the prosecution. And we think there's been a privilege spill. We think that there's been some of that information that was attorney-client privilege actually was conveyed to the grand jury, which would be a violation of Comey's rights, and would possibly lead to the whole thing being dismissed. And the judge says, all right, I'm bringing in Judge Fitzpatrick to handle this matter of the filter team. And so there's 3 tracks here in the Comey case that are all happening at once. There's the track of Judge Nachmanoff and all these trial filings have to do leading up to trial and preparing for trial in early January. There's Judge Currie, who is handling the matter of Lindsey Halligan's appointment. And then there's Judge Fitzpatrick, who's handling the matter of the filter team and this privilege material. Now, because this privilege material may have made its way to the grand jury, and because Lindsey Halligan is the only person who presented anything to the grand jury, well, she's the only prosecutor who presented anything to the grand jury, Judge Fitzgerald and Judge Currie both have interest in what happened with the grand jury. So both judges want the grand jury proceedings, all the filings, all the documents, all the testimony, any recordings. They want to look at everything that has to do with that grand jury. And both of them have a legal basis for wanting to see it. Fitzpatrick, because he's concerned there was a privilege spill. Judge Currie needs to know because she's examining whether or not Lindsey Halligan was lawfully appointed. And if she rules that Lindsey Halligan was not lawfully appointed, then the case may need to be dismissed because she didn't have the authority to present the case to the grand jury to begin with. So those are the 3 tracks that are going, and 2 of them have this overlap of both having an interest, a legal interest in the grand jury proceedings back from September 25th of this year that led to the indictment. So as we go through these, both of them end up giving us information about the grand jury proceedings. And that's what makes it interesting. Now, there was already one hearing in front of Patrick, and Judge Fitzpatrick was not impressed with what the prosecution had done. Because one, they should have already turned this discovery material over. Two, they've had this material that's attorney-client privilege. They've had it for 5 years. Why have they never done a filter team before? Why are we now 30 days past the due date for discovery to be turned over in a case that's supposed to go to trial first week of January, I believe it is, and they're doing filter team stuff? And why is there a question of this attorney-client privilege material being leaked to the grand jury as they were considering the indictment? And we have very good reason to believe that this happened because an FBI agent, the only FBI agent who testified to the grand jury, was exposed to the attorney-client privilege material. We know he was exposed because after the indictment came down and after he testified to the grand jury, he then went to the Office of Legal Counsel to do his due diligence and inform them that he believed he had come into contact with and had viewed attorney-client privilege communications between the defendant and his counsel. And the Office of Legal Counsel pulled him off the investigative team because the information he now knows, he should not have known. That's a big uh-oh. So in the first hearing they had in front of Magistrate Judge William E. Fitzpatrick, he said, I want all the grand jury material. I want all that Arctic Haze material. You need to turn it all over to the court, and you need to turn it all over to Comey. You need everything. This needs to be, you got to give it up because we got to see what happened here. And the prosecution said, we'll comply with some of that, but not all. And they appealed his ruling. And at first they said, Judge Fitzpatrick doesn't have the legal authority to ask for the grand jury materials. He's only supposed to deal with the motion for a protocol team. Judge Nachman, that motion went to Judge Nachmanoff because he's the one who delegated the authority for Fitzpatrick to look at the filtered team. Judge Nachmanoff came back immediately after and said, no, Fitzpatrick has the authority to look at this because that same information, there's a question of whether or not it was used in the grand jury proceedings. He can definitely ask for this material. So, with that backing, Judge Fitzpatrick scheduled a hearing for November 10th, 6 days ago, as of this recording. And leading up to that hearing, both sides made an additional filing. Now, Comey's additional filing is here, and he basically just recounts what happened in that first hearing. Because in that first hearing, the judge agreed, you needed to give me all of this. And that there are unanswered questions concerning the improper use of materials obtained pursuant to the search warrants. And there's a question of whether or not an agent was tainted with that information. And we believe he was because he was pulled off. And then we also believe he conveyed that information to the grand jury, which means the grand jury process is now tainted. So there may be a basis for it to be dismissed. And so disclosure is justified under Rule 6E. And Rule 6E, under precedent, what the court needs is particularized and factually based findings on the record in order for it to unseal and hand over to the defense the grand jury proceedings for them to examine and see what happened in the grand jury. And the particularized and factually based information is there's a privilege spill. We know someone on the investigative team was tainted and was then pulled off the team, and that same person is the only witness who testified to the grand jury. So their filing here really just reiterates everything that was discussed in that hearing. It goes over how they need access to these grand jury materials in order to determine what happened, whether the grand jury improperly obtained materials or the improperly obtained materials that agent had were presented to the grand jury, and if there were any other irregularities here, because there's a list of irregularities, which I've gone over in a separate video and a thread, all the irregularities with that grand jury. And there are one. They have a basis for this. Also, the fact that it was initially there was a 3-count indictment and it failed. And then the 2-count indictment passed, but only by 14 votes, which means by 2. There had to be at least 12 votes to indict. They only had 14 out of 23 or something. So they have, because of these things, they want to take a look at it. And they just reiterate everything that was said in there. I think there was one quote I wanted to tell you from Judge Fitzpatrick. He said when he found out that the defense was in a weird position here, because the defense is a month behind on getting discovery on what the government has against him. And then there's this Arctic Haze materials, which not all of it is attorney-client privilege, but it hasn't been turned over to the defense. And then the prosecution hasn't told defense what exactly this privilege material is, so they could assert privilege over it. And it looks like there was this spill, and it looks like they used this attorney-client privilege stuff. And the judge said, okay, we're going to fix that. We're going to fix it right now. We're going to fix it today. And that's when he issued his order. I think that was it. I think everything else in here I've basically told you about. Yeah. Okay. But before the hearing, happened 11/10, prosecution came in and they made an additional filing. And they tried to argue that the defendant hasn't reached the high bar of deserving to see this material yet. That we can't pierce the ceiling and the secrecy of the grand jury based on the defendant's speculation about what might have happened in the grand jury. So they proposed a compromise of the judge looking at it in camera, which means the judge is going to look at it in private. And that's ultimately what happened. They gave a background on what happened with the proceedings on that day. And let me see. First, they give a background on what's happened since then. But I think they talked about the grand jury in here. Most of this is about how the argument that the defense hasn't met their burden to look at the grand jury proceedings. But I was thinking there was a section where they recounted that day. No, there's not. It must be a different filing that's coming up. Okay. It must be a filing that was made after this hearing then. Okay. They also filed these 2 exhibits. All right. So here's brand new. I haven't covered this in any video yet or any thread. They filed 2 affidavits from 2 FBI agents. Curiously, neither one is the agent who was a witness to the grand jury. And since this issue of a potential privilege spill came up, and since this information came about that this one FBI agent, his name is Miles Starr, since it came out that he was exposed to this attorney-client privilege information and he's the only witness to the grand jury, and then he gets pulled off the whole thing because of that exposure, I have found it very curious that the prosecution hasn't outright addressed that. They haven't just come straight to the heart of the matter and said exactly what happened with that agent and exactly what he testified to the grand jury about, and completely, just demolished the speculation. Instead, they've played this defensive game. And it's made me think that there really is something to the speculation. It's allowed the speculation to live and to become more compelling, right? And then now that they have these two affidavits, and I'm going to read them to you, and they tell a story about the attorney-client privilege material and them looking at it. The fact that they got these two FBI agents to fill out affidavits, but they didn't get one from Miles Starr, is maybe the most notable thing here. It's definitely one of those situations where it's like, it's not what you said, it's what you didn't say. It's the elephant in the room that everyone's ignoring or something. I don't know what analogy to use, but yeah. All right, so this is an affidavit from Francis Nero. Says he's an FBI agent with blah 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 with the bureau. He doesn't go into his history, and he says that he was requested to provide a statement as to the review of evidence from Cellebrite extraction of Daniel Richman's devices. Cellebrite is a program they use where they take your phone, they hook it up to Cellebrite, and they're able to see absolutely every piece of data on your phone. Doesn't matter if you deleted it, doesn't matter if it's encrypted, they see everything. On or about September 12, 2025, while assigned to the director's advisory team, I was requested by Special Agent Spencer Warren to review a Blu-ray disc that contained a full Cellebrite extraction and reader reports of an iPhone and iPad backups. I was requested to review the Cellebrite extraction for conversations between Richman and James Comey. Special Agent Warren handed this agent a manila envelope sealed with red evidence tape that contained the Blu-ray disc with the Cellebrite extraction. Why does he say this agent and not me? Prior to reviewing the contents of the Blu-ray, the director's advisory team consulted with the U.S. Attorney's Office for Eastern District of Virginia, who advised that the FBI was legally permitted to review the information contained on the Blu-ray disc. That is of note. The U.S. Attorney's Office for the Eastern District of Virginia, Halligan's office, advised the FBI that they were legally permitted to review the information on that disc. That's on September 12th. That's before Lindsey Halligan was appointed. Could it be that people that were fired or let go or resigned from the EDVA, maybe it's not because they have some moral objection to Trump going after his supposed enemies, but it's because they made a bad advisement to the FBI here? Just a thought. I opened the envelope and placed the Blu-ray disc in an external CD reader. The Blu-ray disc contained both subfiles and the Cellebrite report in PDF. I reviewed the contents of the disc for conversations between James Comey and Richman. During the review, I discovered text messages between Comey, Michael Garcia, and Michael Schmidt. At the time, this agent did not know the names Garcia or Schmidt. Does he mean himself when he says this agent? You see how there's this third person thing going on? Where it sounds... S.A. Warren handed this agent I obtained the envelope and placed the Blu-ray disc in an external CD reader. The Blu-ray disc contained both subfiles and Celebrite report and PDF. I reviewed the contents for the disc for conversations between James Comey and Richmond. During the review, I discovered text messages between Comey, Michael Garcia, and Michael Schmidt. At this time, this agent did not know the names Garcia or Schmidt. It's just kind of weird that he doesn't say, I did not know. Anyway, next he says, since I did not know who these individuals were or if the chats were relevant, this agent printed the chat so Special Agent Warren could review. Due to the voluminous pages of the Celebrite extraction, I only printed the relevant pages. I handed the printed pages and the Blu-ray disc back to Special Agent Warren for his review. Additionally, I did not participate in any grand jury preparation or drafting of search warrants as it relates to this information. Furthermore, I did not provide the contents of this information outside of Special Agent Warren to those who participated in grand jury. One of the reasons I'm kind of noticing that is because this is an affidavit, so it's kind of supposed to be first person. It's I did this, and then I found this. I was told by so-and-so. And when there's a pronoun change, one of the things I've learned from just some people who are statement analysis people, experts, is that pronoun changes are red flags, and tense changes. Like when they're talking about something in the present and they change talking about it in the past, those are red flags. And doesn't necessarily mean that the person is being deceptive, okay? But it's something that you look for. And when you see enough of those signs and you compare it with other people's statements and other evidence, it can lead you to conclude that person is engaging in some sort of deception. Now, I'm not alleging that here with Francis Nero. I'm not alleging he's being deceptive. But it does stand out to me, that change, because it's not natural. It's not natural to go from, hey, I'm just human, this podcaster is here to present, like, that's what they're essentially doing. I'm saying, I'm thinking this, and then I would jump to this podcaster believe, it's weird. It's not normal. And it could be a result of 3 different attorneys going over the affidavit and making changes to it and trying to get it to where it said, trying to curate it, right? So it could just be mistakes like that. It also could be he wrote it in a rush. And maybe he meant to go back and make it first person I, but and he just missed a couple points. I can't help but notice it though. All right, he says he handed the printed pages and the Blu-ray disc back to Special Agent Warren for his review, and that he did not participate, Francis Nero, did not participate in any grand jury preparation or drafting of search warrants as it relates to this information. Furthermore, I did not provide the contents of this information outside of Special Agent Warren to those who participate in the grand jury. So this stands out to me because he's saying the same thing twice in a way, and he's making it very clear. I, Francis Nero, gave this to Special Agent Warren. I didn't give it to the grand jury. I didn't participate in drafting any search warrants related to this information. I did not participate in the grand jury. He's making sure he is hands off of that. Anything to do with that. Here's the next affidavit. This one's from Special Agent Warren. On or about September 12th, 2025, while assigned to the FBI's Director's Advisory Team, Special Agent Spencer Warren was advised by supervising agent that the case team had consulted with the U.S. Attorney's Office for the EDVA and that agents were authorized to access evidence items in Arctic Haze that were obtained via search warrant. So again, September 12th, we were advised by the U.S. Attorney's Office for the Eastern District of Virginia that we could access this evidence. Special Agent Warren was asked to determine if pertinent emails or text message communications were contained on the evidence items that may be used in preparation for a Richmond interview scheduled for the following week. Special Agent Warren asked Special Agent Francis Nero to review digital evidence containing files from Daniel Richmond's Apple iPad and iPhone. A short time later, Special Agent Warren was approached by Special Agent Nero, who inquired about who Michael Garcia was. Special Agent Nero indicated that some text message communications located were seemingly sent by Michael Garcia. At the time, Special Agent Warren was unaware of who Michael Garcia was or that Daniel Richmond had used any alias identity. Special Agent Nero provided Special Agent Warren approximately 3 to 4 physical printouts of text message conversation threads, showing that Michael Garcia was in communication with individuals such as Michael Schmidt, who's a New York Times reporter, and James Comey. As Special Agent Warren reviewed the communications, Special Agent Warren witnessed a text message thread between Michael Garcia and Michael Schmidt, and a separate text message thread between Michael Garcia and James Comey's phone number. Upon reviewing the content of these messages, Special Agent Warren understood that Michael Garcia was Daniel Richmond. Special Agent Warren also recognized a potential reference to future legal representation contained within the Richmond-Comey text message thread. None of the text messages were used or referred to in the Daniel Richmond interview on September 16th, 2025. So between them realizing this, well, not between, after they realized this, they did interview Richmond on September 16th, but they didn't bring any of this stuff up to him, and that's weird. That's odd they didn't bring it up to him. On the morning of September 25th, 2025, the team was preparing for an indictment of James Comey to occur later that afternoon. Special Agent Warren provided case agent Special Agent Miles Starr and the FBI Office of General Counsel, an attorney from that office, a limited overview of the text message communications to and from Michael Garcia, who was now understood to be Daniel Richmond. It doesn't say it here, but did it take them more than 4 days to realize it? They first look at it on September 12th. They interviewed Richmond on September 16th. Did they not realize it for more than 4 days? Special Agent Warren provided case agents Special Agent Miles Starr and an FBI Office of General Counsel attorney a limited overview of the text message communications to and from Michael Garcia, who was now understood to be Daniel Richmond. Special Agent Warren advised Special Agent Starr and the FBI OGC attorney that some of the messages appeared to reference potential future legal representation. The FBI OGC attorney immediately advised that any of the text message communications referencing potential future legal representation should not be part of the indictment preparation. Special Agent Warren provided the indictment preparation team a 2-page document containing limited text message content from only May 11th, 2017, predating the reference to potential future legal representation. Comey was fired on May 9th. Comey was fired on May 9th, and I remember a footnote from over here that talked about it, what Comey said to Horowitz during an interview later. Must have been in this one. Right there. The defendant was removed as FBI director on May 9th, 2017. He told the Office of Inspector General that, quote, the day after his removal or very shortly after, he retained attorneys Patrick Fitzgerald, David Kelly, and Daniel Richmond. Any claim of privilege involving those attorneys would necessarily arise after May 9th. Special Agent Warren provided the indictment preparation team a 2-page document containing limited text message content only from May 11th, predating the reference to potential future legal representation. But it may already be the case that Daniel Richman is acting as Comey's attorney by May 11th, even if they are talking about future legal representation. I can call an attorney friend right now and say, hey, I need you to be my attorney from this minute forward. Him say, okay. And then I can call him tomorrow and say, hey, I may need you to be an attorney for me next year in this other thing. And he can say, okay. On the afternoon of September 26, 2025, Special Agent Warren received emailed instructions from the FBI OGC attorney to segregate potentially privileged communications and await further instructions from a filter attorney. Special Agent Warren confirmed his receipt of the email, made the case team aware of the FBI OGC's attorney's instructions on Nero's printouts, and advised the team where the documents were quarantined on an adjacent desk. So the day after the indictment, they had to make some moves because they had some potentially privileged communications in evidence that they shouldn't have had. And it would need to go through a filter team. But then they wait until October 13th to file for one. It doesn't look good, does it? It's just not a good look. So hearing happens, okay? The hearing happens later that day, and on November 10th anyway. These filings were made on November 10th. So late that same day, November 10th, the hearing happens over the phone. It's very quick. It's a very quick hearing. And the court orders that there's going to be an in-camera review. The judge himself is going to, and what he wants is all materials relating to the grand jury proceedings, including audio and transcripts. He wants all the testimony to the grand jury, any statements made by the prosecutor or law enforcement officer, or any witness or presence of the grand jury, anybody who was in the presence of the grand jury. He wants everything they got. And he also wants Comey's team to submit ex parte, meaning only to him, a submission that says, this is what we think is there. This is what we believe we have a right to look at from the grand jury. And then that's it right there. Ex parte sealed documents. Okay. Then 2 days later, we get this brief filing from Comey's team saying, hey, we're requesting you to hurry up because we have a motion hearing scheduled for December 9th, and we want it to be advanced to well, actually, this is the one where they're saying we want a hearing moved up because Jessica Carmichael, who's the local attorney, she already has a criminal trial scheduled that she has to work. And then I feel like there was another one where they said they want the judge to hurry up because the trial is only 2 months away. I don't see it. Okay, so then we get motions for a bill of particulars. Or actually, we already had that. Sorry. We get the government's response to a motion for a bill of particulars where they're opposed to it. But I'm gonna skip that for now because I want us to stick with this same track that we're on, dealing with the filter team and the grand jury issue. I'm going to save these for another show. I'm going to save those for another show. this is it. This is what I want to go to next. Okay. So Fitzgerald now, as of November 10th, Fitzgerald, he's looking at the grand jury proceedings. But at the same time that he's looking at the grand jury proceedings, so is Judge Currie. Because remember, she's considering the lawfulness of Lindsey Halligan's appointment. And so she has a hearing coming up, and it's on November 13th. And during that hearing, things didn't go super well for the prosecution. And this is what I already did a video over right here. It's about 25 minutes. But we're going to go into some documents that came after the hearing and after I wrote this thread. First, I'm going to take you through this just in case you don't know. And I'll just go to I'll read through this real quick. That'll be fine. So this hearing, remember, this one is in front of Judge Currie, and it's about Lindsey Halligan's appointment to interim U.S. attorney. And this is also the issue where initially I was not too convinced that Lindsey Halligan is lawfully appointed. I thought Comey's motion related to that was very compelling. And I believe I went over it in episode 349, maybe. Yeah, it was episode 349. I was also wearing a green shirt that day. I really like this green shirt. So it was on that episode I went over that motion to dismiss for unlawful appointment. I found it compelling. And then I said I would give a fair shake to prosecution's response to that. And then it was in episode 353, I think. Yeah. No, it wasn't. It was 352 then. Yeah, it was 352 because I changed my mind. Because the United States motion in support of Lindsey Halligan's appointment plus Pam Bondi's order, I thought was very compelling. And I pointed out to you guys, as I have for a while now, that we may have to rethink Judge Eileen Cannon's dismissal of Jack Smith. Because if Lindsey Halligan's lawfully appointed, I think Jack Smith was too. And I was of two minds back in 2024 in the summer when Judge Cannon dismissed Jack Smith's case. Because I was like, I get it. I get why he shouldn't be special counsel because he's not a Senate confirmed U.S. attorney. But he's not just appointed under that statute. He's appointed under other statutes as well. And the AG certainly has the power to pick prosecutors and empower them to investigate and prosecute cases. And it seems like Judge Eileen Cannon it seems like she can't do this. We can't have a system where the AG can't select a prosecutor to prosecute. And the filing from DOJ, which came from Henry Whitaker, not just the prosecution, I thought was excellent. I read the whole thing, and yeah, I thought it was great. So Henry Whitaker is at this hearing in front of Currie, and she was skeptical of the DOJ's case. And during this hearing, she said that the grand jury transcripts confirmed that Miss Halligan acted alone in presenting the case to the grand jury. That's a problem, guys. Because if the judge rules that Lindsey Halligan is not lawfully appointed, then the case gets dismissed. If there was another attorney in the room, as is usually the case, the common practice is that a line prosecutor presents to the grand jury, signs the indictment, and then the U.S. attorney also signs it. But for whatever reason, in this one, only Halligan presented and only Halligan signed. meaning that if Halligan falls, so does the case. And that's why she highlighted this. Ms. Halligan acted alone without any other government attorneys in the room, and that could threaten both cases against Comey and against Letitia James if Currie ultimately decides Halligan was invalidly appointed. A portion of the grand jury proceedings that led to Comey's indictment was missing, said the judge. Put a pin in this. Leaving certain aspects of Halligan's interactions with the grand jury unreviewable. Currie said that it appeared that at about 4:28 p.m. on the day the indictment was returned in September, there was no court reporter in the room to transcribe the proceedings, leaving no record of the final minutes of the grand jury session. And so it looks like they gave Currie the transcript and some other things, other materials from the grand jury process. But a plain reading of those things makes it at least appear, and that's the word, that's what she said, appear, that there's some stuff missing. That's not good. It's not good for a judge to think that you left some things out that they ask you for. The Justice Department attorney Henry Whitaker urged Currie to treat questions about Halligan's appointment as, at most, a paperwork error, and emphasized that Bondi had reviewed the grand jury materials and agreed to retroactively ratify Halligan's actions, even if her initial appointment is deemed invalid, which we looked at that order from Pam Bondi, and I have real questions over whether or not an AG can retroactively appoint someone to something. I'm not sure that that's a thing. But Currie said the missing component of the grand jury transcript called into question the sufficiency of Bondi's review. Quote, "It became obvious to me that the Attorney General could not have reviewed those portions of the transcript presented by Ms. Halligan," Currie said. The judge also questioned why Bondi signed a statement saying she had reviewed Halligan's actions before the grand jury when transcripts of some of that presentation did not exist. The answer is she couldn't have. Whitaker said Bondi had reviewed the material facts of Halligan's grand jury presentation, which showed that the grand jury made a decision based on facts and the law. Attorneys for Comey and James said it's not possible for the Justice Department to retroactively empower a prosecutor who acted without legitimacy to secure an indictment. In one head-turning moment, which this is a moment I've been expecting to get raised, in one head-turning moment, Whitaker said the Justice Department takes issue with one aspect of U.S. District Judge Eileen Cannon's ruling last year, tossing Special Counsel Jack Smith's prosecution of Trump on charges related to classified documents kept at Mar-a-Lago. Whitaker said that Cannon went too far. The issue could have relevancy for Halligan's appointment, since Bondi's recent order claims to retroactively appoint Halligan as a DOJ prosecution under several alternative statutes. I told y'all that this case and the matter of Halligan's appointment is going to give some folks a case of the cognitive dissonances. Defense attorneys also pressed Currie to treat her role in a more grandiose context. That is, the presentation of the separation of powers and checks on presidential power. Abby Lowell argued that this case is a bulwark against one branch aggrandizing its power against another, which, hey, Abby Lowell he's pretty good. You don't have to like him, but he's pretty good, and that's a good angle to go for. You take a senior judge, been there on the bench a long time, since the 90s, and you tell her that this is an out-of-control executive who's encroaching on the power of the judicial branch. And maybe you appeal to her sense of, I don't know, sanctimony or something. Her desire to protect her turf, right? He told her there would never be any reason to go through Senate confirmation again if you don't rule against Halligan's appointment, because Trump or any other president could just appoint interim attorneys indefinitely. Currie seemed to tip her hand in her first question Thursday, asking if Comey's defense attorneys had seen the declination memo related to the case. They have not. And that's also something for us to put a pin in. That's very important. Now, it hasn't come time. I don't remember what date DOJ has to turn over Brady material. So there's three types of discovery. There's the evidence the government has against you, the evidence the government has that actually is to your benefit. So there's inculpatory evidence, there's exculpatory. That's the Brady material. That's the stuff they have that would go to your defense. And then there's the jinx material, which is the communications between the investigators and the prosecution that might show something unethical going on. Okay. So, and that stuff played a big role in the Trump cases. Trump's team was very much after the communications between NARA and the White House counsel's office and DOJ and FBI in they're putting together the Docs case, because there may have been either unethical or illegal coordination between those different groups. The fact that what happened here in this hearing is that both sides presented their arguments to the judge after already making filings on the unlawfulness or lawfulness of Halligan's appointment. And we've read both of those filings in previous episodes. And then they go to this hearing and both sides present, I don't know how many minutes they had, but they presented their argument, a concise and emphatic appeal to the court to rule in their favor. And then her first question is something that didn't come up in either filing, which is Durham's declination memo. And I think that shows her mind is where her mind is at in this, is that this is a investigation that already happened. He was already looked at for this material, for these supposed leaks to this exact person. And both of them were already investigated 5 years ago. And the evidence that was obtained back then through 4 search warrants and all sorts of other investigative methods did not surface enough evidence to indict Comey, Richmond, or anyone else. And there is a declination memo to that effect. And they decided not to prosecute. And there's also the Comey memos that IG Horowitz looked at. And remember, they were up-classified by McCabe after Comey was fired. And after Horowitz looked at that, there's a declination memo about prosecuting Comey for any of that, I believe, if I'm remembering correct. So this, to me, this indicates that this judge's mind is she's weighing whether or not this is not a vindictive prosecution, but she's thinking about how the president appointed Halligan and the circumstances of him appointing her, and then her immediately bringing this case days before the statute of limitations expires, rushing through a grand jury, keeping the grand jury late. All of these irregularities with the grand jury. And I think she's thinking about how it looks. And that tells me she's aware of more than what's in the filings. And I mean the filings that were directed to her. And I think she's thinking about perhaps whether or not she wants it. In other words, I think she's considering more than the bare question of whether or not a president can appoint back-to-back interim U.S. attorneys. And that might be because she's already made her mind up on that specific point. And her mind might be, yeah, presidents can do that. And there's a long history of presidents doing that. Remember, she's been on the bench since the 90s. So she's seen Presidents Clinton, Bush, and I don't know if Obama did it, but definitely Bush and Clinton made sequential U.S. attorney appointments, interim appointments, while they waited for a Senate confirmation to go through. And so I think that I might be reading too much into this, but this is her first question. And that's why it stands out to me. If it was a one among many questions, I wouldn't be going here. But the fact that it's her first question, it makes me think that she's already made her mind up on the sequential U.S. attorney appointments. And if she's already made her mind up, if it was against Halligan, she wouldn't ask this question. She wouldn't need to know, I don't think. She wouldn't be curious about this because it wouldn't matter. But I think because her mind is made up that Halligan is lawfully appointed, she's searching for something else here in order to hang her ruling on. Does that make sense? I could be reading too much into it, but it stands out to me that was her first question. All right. Now, in previous cases, actually, also I should say, the judge also seemed intimately familiar with recent decisions in other courts that found 3 of Trump administration's other picks for temporary U.S. attorney roles were illegitimate. But here's the key thing. In those cases, judges ruled that even though the appointees, which were Alina Habba, Brad Asaley, I think is his name, and there was one other in Nevada, I always forget his name. Even though the judges ruled that those appointees were disqualified as interim U.S. attorneys, which I think they got those decisions wrong, the cases they supervised could continue because other career prosecutors had signed off on them. But here, with James Comey and Letitia James, only Halligan signed off on them. Big problem. Big problem. Now, after the hearing was over, or as the hearing concluded, she promised that she would issue a ruling on this issue before Thanksgiving. So I'm thinking probably next week. Within the next 10 days, I'm thinking she's going to issue a ruling. And it could be that, I mean, it's kind of a, I don't know what the effect of AG Bondi's order is against this. I'm not sure. But it seems like if she rules that Halligan was unlawfully appointed and doesn't have the authority of a U.S. attorney, then the grand jury indictment has to be thrown out because she wasn't empowered to bring it in the first place. So the case is under threat. There's no two ways about it. The case is under threat. Now, something interesting happened right after the hearing, or the day after. A new filing was made to, quote, clarify the record. Where did it open up to? Actually, here. I'm getting all my tabs mixed up. Oh, and then I just closed it. That was super pro. There we go. There we go. I must be feeling better, right? Making these super pro moves, closing the very docket I'm working on. Pro move after pro move right here. If you enjoy these pro moves, consider supporting the show. Make sure you hit like, leave me a comment. If you're so inclined, buy me a cup of coffee, get yourself some honey or some salsa or some chili. Manly Cans, if you're looking for gifts, Manly Cans, you use my link, they'll send me a few dollars. JustHuman.substack.com if you want to join the core of my Just Human support team. Okay, let's try this again. I planned all that. It was all purposeful so I could plug myself. All right. Okay. Informative notice clarifying the record. On November 13th, 2025, Judge Currie held a hearing on defendant's motion to dismiss the indictment based on unlawful appointment. At the hearing, Judge Currie 1 noted an alleged gap in the grand jury record, referring specifically to the period beginning at 4:28 p.m. Remember I told you to put a pin in that? When the transcript reflects that U.S. Attorney Lindsey Halligan and the court reporter exited the grand jury room, and 2, noted U.S. Attorney General Pamela Bondi did not have all the grand jury materials at the time of her ratification. Accordingly, the government respectfully requests the court take notice of the attached declaration from Lindsey Halligan and the attached ratification from AG Bondi dated November 14th. Okay. So let's look. The first one. Declaration of Interim United States Attorney for the Eastern District of Virginia, Lindsey Halligan. At the November 13th hearing, Currie expressed concern regarding an alleged gap in the grand jury record, referring specifically to the period beginning at approximately 4:28 p.m., when the transcript reflects that I, Lindsey Halligan, and the court reporter exited the grand jury room. By identifying that specific time frame, the court placed the timing of the proceedings in dispute. Accordingly, I, Lindsey Halligan, submit this declaration to clarify the precise sequence of events on September 25th, to confirm that the grand jury transcript accurately reflects the full extent of my appearance before the grand jury, and to explain that the period in question consisted solely of the grand jury's private deliberations, during which no prosecutor, court reporter, or other person may be present pursuant to Rule 6D of the Federal Rules of Criminal Procedure. There are no missing minutes, contrary to the suggestion raised by the court. On September 25th, 2025, I presented the case of United States v. James B. Comey Jr. to a federal grand jury in EDVA. I reviewed the full transcript of the grand jury proceedings, and the transcript accurately reflects the entirety of the government's presentation and presence in front of the grand jury. There was no additional presentation, interaction, or discussion with the grand jury outside of what is reflected in the transcript. Below is a brief timeline of the events of that day. September 25th, I appeared before the grand jury after introducing myself and the case proposed for indictment. The case was presented through testimony. At the conclusion of the presentment, I provided a brief summation to the grand jury and then departed along with the court reporter. The process of presenting the indictment took place from approximately 2:18 p.m. to 4:28 p.m. Approximately 2 hours later, at 6:40 p.m., I was notified by then First Assistant United States Attorney Maggie Cleary, who I believe has since left the office, I think she resigned, that the grand jury had returned a true bill as to the presented count 2 in count 3 of the indictment, and that the grand jury had not returned a true bill as to the presented count 1. I then proceeded to the courtroom for the return of the indictment in front of the magistrate judge. During the intermediary time between concluding my presentation and being noticed of the grand jury's return, I had no interaction whatsoever with any members of the grand jury. This time represents the grand jury's private deliberation, which was done in secret with no one but the members of the grand jury present, consistent with Federal Rule of Criminal Procedure 6D2. I was never present in front of the grand jury alone. At every moment I was in front of the grand jury, the court reporter was also present. Signed, Lindsey Halligan. Now, folks, that's a bit of a different characterization or telling of that day than what we've been presented with prior to now. The way it's been represented to us in court filings and in media reports until this day, until this filing, was that a 3-count indictment was presented to the grand jury and it failed. And then a 2-count indictment was presented and that one passed. And that the grand jury was kept there late, past normal hours. They were kept there until 6:40 p.m. But the way they're telling this now is that no, there was one indictment presented. It was 3 counts. And the grand jury voted on each count independently. And the first count failed, but the other 2 proceeded. And they weren't kept there. They deliberated past closing hours. That's a bit different than what we've been told so far. And this timeline, the way Lindsey Halligan presents it here, it resolves some of the questions and some of the irregularities that the defense has pointed out, doesn't it? And that media has pointed out about the grand jury proceeding. And I wish they had just done this earlier. Now, here's Pam Bondi's filing. She says, on October 31st, which is the day she sent that order, on October 31st, 2025, and based on the record of the grand jury proceeding that was available to the government at the time, those are some caveats, I ratified the actions of U.S. Attorney Lindsey Halligan before the grand jury and her signature on the indictment returned by the grand jury in the case of United States v. Comey. The district court has subsequently raised questions about the completeness of the record of the grand jury proceedings presented to me at the time of that initial ratification. For the avoidance of doubt, I have reviewed the entirety of the record now available to the government and confirmed my knowledge of the material facts associated with the grand jury proceedings. Based on that knowledge, I hereby exercise the authority vested in the Attorney General by law, including 28 U.S.C. 509, 510, and 518b, to ratify Ms. Halligan's actions before the grand jury and her signature on the indictment returned by the grand jury. And I'm going to use this opportunity to show you guys something. This is Special Counsel Jack Smith's landing page on the DOJ archives. And if we go and look at the order appointing Jack Smith, what does it say? By virtue of authority vested in the Attorney General, including 28 U.S.C. 509, 510, 515, and 533, in order to discharge my responsibility to provide supervision and management of the DOJ and to ensure full and thorough investigation of certain matters, I hereby order as follows. John L. Smith is appointed to serve as special counsel for the United States Department of Justice, and he is authorized to investigate blah, 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 and also as well as any matters that arose or might arise directly from this investigation or that are within the scope of 28 CFR 600.4. Now look at this right here, 509, 510, 515, and 533. What statutes is Halligan appointed under? 509, 510, and 518B. The 509 and 510, if I remember correctly, those empower the AG to hire attorneys and other staff to work for DOJ. All functions, it's what empowers them to hire what are called inferior officers. 509, functions of the Attorney General. All functions of other officers of the DOJ and all functions of agencies and employees of the DOJ are vested in the Attorney General. And then let's do 510. So 509 is, I'm the Attorney General and I have the power to hire inferior officers. 510 is, the Attorney General may from time to time make such provisions as he considers appropriate, authorizing the performance by any other officer, employee, or agency of the DOJ of any function of the Attorney General. So any power that the AG has, he can then empower someone beneath him to exercise that authority, that power. So you see the overlap between Jack Smith's appointment and Lindsey Halligan. It's the bare bones hiring power and delegation of authority that the AG has at all times. Cannon may have been right to go after the special counsel statute. Say, no, he can't be a special counsel with a special counsel's office because he's not Senate confirmed. But she can't take away 509 and 510. And I believe that is what Henry Whitaker meant by Judge Eileen Cannon went too far. And I think that's why when Henry Whitaker said that at most, Halligan's appointment is a paperwork error, I think he's right. And I think that at most, I think it's fair to say now, at most, Jack Smith's appointment was a paperwork error. And I said that back then. I don't know how many of you remember, but I said it back before he was dismissed as we were going through Ed Meese's brief and the motion to dismiss for unlawful appointment. I remember going through it and I was of two minds I kept on using that phrase. I'm of two minds on this. On the one hand, Jack Smith is not Senate confirmed, so he can't be special counsel. But on the other hand, the AG has the power and the authority to hire inferior officers and delegate to them his power to enforce the laws of the United States, to investigate and to prosecute, to conduct legal proceedings. And you can't take that power away. And look right here. Here's the order appointing Lindsey Halligan. Look what she's appointed under. 28 U.S.C. 509, 510, and 515. What was Jack Smith? 28 U.S.C. 509, 510, 515, and 533. If I remember right, 533 has to do with the funding, has to do with their budget. I'll go ahead and look at 515 first, because that's both Smith and Halligan. 515 is the authority to conduct legal proceedings and to hire others and give them a salary. The Attorney General or any other officer of the DOJ or any attorney specially appointed by the Attorney General under law may, when specifically directed by the AG, conduct any kind of legal proceedings, civil or criminal, including grand jury proceedings. Each attorney specially retained under authority of this DOJ shall be commissioned as special assistants to the AG or special attorney and shall take the oath required by law. I believe 533 has to do with the funding of Jack Smith's office. I could be wrong. Authorize the Attorney General to appoint officials for specific duties, including detecting and prosecuting crimes against the United States. This section explicitly states that it does not limit the authority of other departments and agencies to investigate. No, I'm incorrect. It doesn't have to do with the funding of his office. It has to do with his jurisdictional what's going on? Yes, I'm human. It's literally the name of the show. I don't know why Cornell didn't come up first. This is Library of Congress. That's not going to help me. Anyway, so Lindsey Halligan is appointed under those same provisions, same statute as Jack Smith. And that's why I've been telling you guys as soon as this challenge was brought up, that if Lindsey Halligan's appointment is legal, if it's valid, then so was Jack Smith's. May not like it, but it's the truth. It's the truth. Okay. And so to wrap that up, Judge Currie, does she go as far as Judge Eileen Cannon did? See, this is that case of cognitive dissonances I was talking about, where it's like, you may want Jack Smith his cases to be dismissed for unlawful appointment, but here you are wanting Lindsey Halligan to not be dismissed for unlawful appointment, even though they were appointed under the exact same statutes. Legally, there's a dissonance there. And maybe vice versa. Maybe you want Halligan dismissed, but you wanted Jack Smith kept in. So this is what's before Judge Currie. Let me know. I really would be interested in you guys' thoughts. I know I'm kind of having fun here. Like, I'm kind of poking at my audience about the cognitive dissonance, but I don't assume that all of you are, that you're biased or, that you're struggling with it that much. To me, it's a very interesting legal situation. And I like things that challenge our biases and challenge us to consider what we want versus what is legal and whether or not it should be. And so to me, this is all fun. It's fun to chew on. And I would be interested in what your thoughts are on it. So feel free to let me know what you think in the comments, and agree or disagree. As always, agree or disagree. It doesn't matter. Let me know what you think. Also, it makes me feel good whenever things I present, make you think. All right, I spent longer on that than I really wanted to, but I have the next segment of the show is going to be about the email exchange between this FBI agent and the Washington field office who wanted to open an investigation on Hillary Clinton and Fusion GPS and the hidden payment to Fusion GPS through Perkins Coie for the Steele Dossier. And that should have gone forward. And if it had gone forward, it would have shown that the Steele Dossier, which was used as the premise and as to take out FISA warrants and to start the whole Crossfire Hurricane and Russiagate stuff up, and everything that flowed from that Steele Dossier, the 2017 ICA, all of that horse manure was paid for by Hillary Clinton. And an FBI agent in the Washington field office, no less, wanted to investigate it, and he was blocked from doing it. So what I'm going to do is I'm going to now in this video, I'm going to stitch in that segment, and we're going to go through it page by page. I promise you it will be well worth your time. And then I'm going to come back at the end of that, and I'm going to close out the show with a short segment I've been wanting to present for a few days now. I think you're going to really enjoy. So me from the past is now going to present to you, and then I'll come back here in just a moment. Hey guys, so I'm sitting here making a video about something different, and Senator Grassley puts out some really interesting emails and an FBI EC, a memo that is used to either open or close to open an investigation. But in this instance, the investigation wasn't opened, and it has to do with Hillary Clinton, her campaign, Perkins Coie, Fusion GPS, and that nexus of corruption. And I made a thread on it over on X. You may have seen it if you're following me. And the thread is just highlights from these emails and from this EC. But I thought it would be worth making a video about it and taking you through the document itself. So that's what we're going to do. So this comes as, you know how Grassley and Johnson are. Grassley and Johnson are constantly sending letters to the FBI and the DOJ and asking them questions and requesting records. And I love it. I love that they do that. And that's what this one is. There was already a previous letter to this, which was sent, I don't know, way back on July 18th. And now they've gotten a response. And part of what's going on here is that they have a whistleblower, an FBI agent, who I think is likely the FBI agent who we're gonna end up referring to as our plucky FBI agent. Because he was wanting to investigate the Clinton campaign. So Grassley writes to Attorney General Bondi and FBI Director Patel, hey guys, back on July 18th, 2025, I wrote to you requesting all records related to several of my ongoing investigations, including a whistleblower allegation that FBI agents attempted to open a criminal case into the Clinton campaign relating to his financial relationship with Fusion GPS and potential FEC violations. As I noted in that letter, the Clinton campaign and the DNC ultimately paid fines to the FEC for improperly handling the payment of the Steele Dossier as legal services and consulting. Actually, I should say labeling that payment as legal services and consulting. I also noted whistleblower allegations that the Clinton campaign investigation was declined by Richard Pilger from the Justice Department's Public Integrity Section, and J.P. Cooney, who worked in the U.S. Attorney's Office for the District of Columbia at that time. Notably, my letter was based on years of investigative work with many courageous whistleblowers. Since then, your offices have produced records based on these whistleblower disclosures. The records consist of email communications, as well as an FBI electronic communication titled USADC and PIN prosecutorial consultation for investigation DNC Fusion GPS FEC violation. According to the FBI EC, sorry. That was super pro of me to do that. According to the FBI EC, it was U.S. Attorney for D.C. and the Public Integrity Section, specifically Cooney and Pilger's opinion that, quote, the DNC and Fusion GPS FEC violations matter was not predicated for a criminal investigation. And there wasn't enough there to open a criminal investigation. Emails obtained by my office with the subject line Campaign Legal Center Complaint -FEC appear to show that Cooney and Pilger stopped investigative steps into the matter. In email exchanges spanning from June 5th, 2019 to June 21st, 2019, between FBI agent, Pilger, Cooney, and Anna Lou Tyrrell, the FBI agent asked questions as to why the Clinton campaign Fusion GPS DNC matter did not make, quote, a good candidate to open an investigation, given there appeared to be unambiguous concealment by the DNC and Clinton campaigns for payments related to the production of the Steele Dossier. Now, who are these people? Now, I already told you who Pilger was, and Pilger's over at DOJ Public Integrity Section. J.P. Cooney is working in the U.S. Attorney's Office for the District of Columbia. But Anna Lou Tyrrell is a person within the Treasury Department's FinCEN network, their financial crimes network. And not soon after these emails and this EC happened in June of 2019. By September 2019, she was deputy director of FinCEN. Okay. And she doesn't respond to these emails, but she's looped in on them. And that's one of the most fascinating things about this. Watch her be, maybe she's the whistleblower or one of the whistleblowers. I don't know. So Grassley then goes on to say, in one response, Pilger accused the FBI agent of creating jinx material. Jinx material is discoverable communications that a defendant could go after in looking for some sort of unethical coordination or something like that, and threatened to turn them over in other matters to cross them for bias, rush to judgment, yada, yada, quote. Further, in a June 21st, 2019 email, one FBI agent noted that Pilger has finally acknowledged my questions. His answers usually contain some veiled threat I believe is intended to have a chilling effect and stop me from asking questions. I have never been met with such suspicion or responses intended to have me go away. The FBI EC, as well as the internal emails my office has obtained, raise serious questions about Pilger and Cooney's decision-making. Indeed, this is not the first time my investigative work has placed a light on Pilger's work. On October 7th, 2021, as ranking member of this committee, I released a staff report on which Section 6 in that report is about Pilger and his efforts to undermine the DOJ's election-related efforts during 2020. As such, in order for Congress to conduct proper oversight of the DOJ and FBI's handling of the Clinton campaign and Fusion GPS investigations, please provide the following no later than November 27, 2025. And what Grassley wants is all records related to the matter described in these documents, which is the DNC and Fusion GPS FEC violations. Provide all communications to and from Richard Pilger, J.P. Cooney, and Lou Tyrrell related to that, and provide all emails and records in Exhibit 1, which I'll show you what Exhibit 1 is here in a minute, as well as those records produced in conjunction with the request in question 1 and 2 in unredacted format. So that's what Grassley's after. We'll see if he gets it. He does tend to get a lot of what he asked for, which is pretty great. Now, if you don't remember, just in case you need a refresher, you know who the DNC is, but Fusion GPS is Glenn Simpson, and Fusion GPS was contracted by Perkins Coie, the law firm, Mark Elias, who was the attorney for a DNC, and Hillary Clinton's campaign, who retained Fusion GPS and had them do, Hillary Clinton's campaign, which retained Perkins Coie, and through Perkins Coie, hired Fusion GPS to do opposition research on first Joe Biden during the primaries. And that's how you get all the Ukraine allegations against the Biden family. If you don't know, the allegations against the Biden family and supposed corruption in Ukraine that they were involved in is a Clinton/Fusion GPS product that was used against Biden to keep him out of the primaries so that she could more easily get the nomination in 2016. They then converted some of those allegations into allegations against Trump and his family. That's why there seems to be a copy-paste there between allegations against Hunter Biden and allegations against Don Jr., allegations against Biden himself and allegations against Trump. There's this not symmetry, but it's like they just changed the nouns. They changed the person and they changed the country it was in and just swapped Ukraine for Russia and swapped Hunter Biden for Don Jr. And yeah, that's why that's there. The other thing is that Fusion GPS ended up contracting with Orbit and Business Intelligence, which is Christopher Steele's outfit, and that's where you get the Steele Dossier. It's a big old nexus of political corruption, right? And later on, they hid it and they denied it and they lied about it over and over again. And then finally, the FEC caught them, and Hillary had to pay $250,000 or something. It's been a while since I've looked at it. I don't remember exactly. Anyway, so in June 2019, that was in October of 2017 that it started. They had to end up admitting it, and then I don't remember when exactly they had to pay. Anyway, so what's going on here is that this FBI agent has decided that he's going to examine opening up an investigation. Okay. So what he does, and actually what I should do is I'm going to scroll down here because these are I'm going to present these to you in a certain order. Okay. I think it's best to present it in chronological order. So June 5th, 2019, 9:44 a.m. FBI agent, we don't know his name. It's redacted, but he's with the Washington field office. He's a special agent. He may be the whistleblower. I don't know for certain. He may be one of more than one whistleblower that has to do with this. But anyway, June 5th, 2019, 9:44 a.m., he sends a email to Rich and JP, Pilger and Cooney. It says, redacted liaises with government watchdog groups. So I don't know who redacted is. They could also be a whistleblower. Don't know. Redacted liaises with government watchdog groups. I'm new to the squad, inherited the watchdog file, and have recently made my rounds. A complaint from over a year and a half ago was ultimately brought to my attention. I wanted to provide it to you so we can obtain an informal consultation on whether this unambiguous concealment of a disbursement is sufficient to open an FECA case. And then it says right here, Campaign Legal Center Exec Summary, FEC complaint, Hillary for America, and DNC failure to disclose. Date October 25th, 2017. CLC, so Campaign Legal Center, filed a complaint with the FEC alleging the Democratic National Committee and Hillary Clinton's 2016 campaign committee violated campaign finance law. They failed to accurately disclose the purpose and recipient of payments for the dossier of research alleging connections between then-candidate Donald Trump and Russia, effectively hiding these payments from public scrutiny, contrary to the requirements of federal law. And then they also lied about it over and over again. It appears it was first reported publicly that the DNC funded Fusion GPS in October 2016. But for a year, the DNC and related groups or associates, I'm told, denied it, or didn't respond to the allegation until Perkins Coie confirmed it in October 2017, possibly because ignoring it was no longer tenable. From a quick internet search, I pasted a snippet from 2 October 2017 CNN and New York Times articles, which appear to supplement the complaint. But I'm not going to dig into this until I hear from either of you. And then it's a copy-paste about those things, and Podesta being asked about it in an interview, and then Senate Intelligence Chairman Richard Burr bringing it up, and the New York Times, talking about the law firm Perkins Coie, and its lead lawyer, Mark Elias, spoke on a condition of amnesty to discuss sensitive information. The law firm's payments to Fusion GPS for the Russia research ended just before Election Day. And then down here it says, Rich, under separate cover, I sent you a matter from SAR that I also am seeking an informal consultation on. Now, we don't learn anything else about that from this. But a SAR is a suspicious activity report. And that's where that Anna Liu person from Treasury Department's FinCEN division comes in. And I don't know if that SAR report has to do with Clinton or the DNC or Fusion GPS. I don't know. But it just seems kind of weird to me. This whole thing is about those groups. And then at the bottom, he puts, Rich, under separate cover, I sent you a matter from a SAR that I also am seeking an informal consultation on. So my suspicion is it's probably related. Because he doesn't say a completely separate matter. I don't know. But very interesting that that's included there. And first thing that comes to mind is Clinton Foundation. Very first thing that comes to mind. All right. So that's his first email. Then, let's see, this is 9 days later. 9 days later. And as you can see, it doesn't say in the to section. See right here, it doesn't list the Treasury girl. No offense, Anna Liu. She's not listed as getting this email here, getting this bump. But I wonder if she got this one right here. I don't know. Anyway, he re-ups it. He bumps it, saying following up on below because they haven't responded to him. It's been 9 days. Okay. Then he gets a response from Cooney over at the U.S. Attorney's Office. But if you look at who Cooney sends it to, he sends it to Pilger. And then I guess it's just to our FBI agent. But it looks to me like there's room in there for there to be another recipient. And see, someone is CC'd. And I don't see who they are. So maybe that's Anna Lou. I don't know. Anyway. Says, thank you for sending me this. I apologize. I thought that we had gotten back to you on this. My office is really interested in working FECA matters. So please keep them coming. Richard and I happened to successfully try a false expenditure reporting case together in Iowa alongside your squad back in 2016. It is the only such prosecution of which I am aware. I do not, however, think this is a good candidate to open for a false reporting case. The FEC has approved campaigns hiring vendors, or in this case a law firm, and that vendor contracting with third parties to provide services. Although I have not looked at the FEC report, any money paid to Fusion GPS for the dossier through Perkins Coie was probably reported as legal services or something like that. Although not typically what we think of as legal services, I think we would have an exceedingly difficult time proving it was a willfully false report. That is particularly so given that Elias, when questioned, disclosed the existence of the Perkins Coie Fusion GPS contract. In the case that Richard and I did together with your squad, we charged redacted staffers with false reporting based on their concealment of some amount of money payment to a redacted to induce him to redacted. We were armed with the following compelling facts, none of which I see present in this case. He's got a bullet pointed section here next, and it's kind of difficult. It's so redacted that it's kind of difficult to get the gist of it. But basically he's saying that the facts here this was different. He details how, and I wish it wasn't so redacted. I feel like it shouldn't be because this is a case that's on the books. So I think it could be looked up. I don't think it's confidential, but I don't think it's sealed. But anyway, he talks about in these bullet points here about how that case was brought forward because these were the things about it that made it chargeable, where they could prove the willfulness and that the payments were purposefully concealed to hide the nature of what was really going on. The redacted outfit created false invoices to the campaign, indicating that they were for communications equipment when they weren't. And the redacted allowed their treasurer to book the payments to the redacted outfit on the FEC report as being for communications. So on the report, all you could see was the name of the firm and the purpose, communications, and that was false. The payments were actually to, and then it's redacted. So the deception was pretty blatant there, including false documents. And he goes on to say here, the Clinton campaign made payments to Perkins Coie for legal services, which it did in fact perform, including subbing out to a vendor like Fusion GPS. And once questioned, Perkins Coie publicly disclosed that it had contracted with Fusion GPS. We just don't have the type of direct concealment and purposeful use of a pass-through that we had in that other case, which was essential to carrying our high burden of willfulness. Sorry for the long email, but I wanted to give you as much of a detailed explanation as possible for why this is not a good candidate for a criminal investigation. Please feel free to give me a call if you want to discuss more. Signed, JP. Now, when first reading this, his explanation makes a lot of sense to me. Even though I don't like it, and I would much rather get an email from like, yeah, go for it. We gotta hunt down this type of I don't even know what to call it. This looks very corrupt, the way they went about this. It looks like they used their Perkins Coie as a cutout for their payments to Fusion GPS, and Fusion GPS got the Steele Dossier, and it was presented to the FBI as being an intelligence report from a well-known intelligence analyst and someone who had been a CHS for the FBI. So they took it on good faith that it was a credible report, and it led to Crossfire Hurricane and all. Like, that's what you're hoping to see, but that's not what he says. And his explanation, honestly, guys, pretty reasonable. I'm not saying I agree with it. I don't know. I don't know that I agree with it. But what he's saying, as far as when you compare this case, there was a similar case that was already brought, and the facts that it had compared to the potential case against Clinton, it looks like it'd be very difficult to convince someone that this was purposeful concealment of the payments and of the relationship, especially since it was no longer concealed. And when Perkins Coie was asked about it, they came forward. Now, if you don't think it sounds reasonable, we're going to get into it a little bit more, and it's going to be explained again, and it'll make you a little bit more sense. But don't worry, this gets intriguing. So June 18th, remember that he had responded June 14th. Also, remember, this is an attorney who would prosecute it. So it's his job to think of reasons to do it and reasons not to. Okay? That's literally his job. So that's what he does. Now, I wish he had seen the other side a little bit more, but anyway. All right. June 18th, days later, our FBI agent friend here decides to reply. And he says, JP, parentheses, and Rich, if you want to chime in. I was on the road last week and we reread the below email today to digest it and learn about a false reporting case. And I have some questions. On a side note, someone from Public Integrity Section, maybe Rich, is supposed to come to train our squad on some of the themes of my questions on June 28th. So maybe addressing these issues there will be useful. I'm trying to better understand 3 topics as they relate to FECA, and this matters, so I can work these cases smarter. All 3 topics have the same theme, which is, what is the standard for opening a FECA investigation, not prosecuting an FECA violation? 1, the standard for opening an FECA by investigation, not to be confused with the standard for proving or prosecuting an FEC criminal violation. The attorney had just replied. He didn't reply saying anything about opening an investigation. He replied with about what it would prove, what they would have to prove in court. His whole picture, his sight picture on this was, we wouldn't be able to get this ball over the line in the courtroom based on what we have. Okay, but you haven't investigated it. And that's what the FBI agent is about, investigations. So he's like, hey, the standard for opening an FECA investigation, not to be confused, underlined, with the standard for proving or prosecuting an FECA criminal violation. 2, the role of mitigating action by individuals subject to FECA violations and how that affects opening investigations. 3, FECA rules on disbursement reporting and how that affects opening investigations. 1, the standard for opening, not prosecuting. From my experience with FECA thus far, I have been told you want a viable path to a willful case before opening, and generally that viable path thread is some sort of concealment. If that articulable concealment is theoretically for a material reason, such as a conduit, false reporting, etc., all the more justification for opening. From my experience with all violations, to find those compelling facts for a prosecution, you have to do some investigating. Is that generally correct? Standard for opening your redacted case, at what point in the fact pattern was the false reporting case opened? The facts you provided are compelling, evidenced by a prosecution. But which of those facts were known before opening the case? Was the evidence of direct concealment and purposeful use of a pass-through known before you opened the investigation? Man, these are great questions. These are great questions. For this matter, I sent to you because, one, there appears to be an unambiguous concealment. We don't know if it was willful yet. And two, with hindsight on the events surrounding Fusion GPS these past 3 years, this concealment appears to bring a new meaning and represents a viable path to why it was reported this way or not reported. Now, I wasn't born yesterday. I know the name Mark Elias, and I know that path likely goes through a steep hill, if not a sheer cliff, to find those compelling facts. In other words, your points are well taken in terms of the difficulty of prosecuting or finding those compelling facts in this matter. But why is it not a good candidate to open an investigation? Possibly answered when responding to my above questions, but it also brings me to the next topic. Topic 2, mitigating actions by individuals subject to FECA violations and how that affects opening investigations. One of your main mitigating points is, quote, particularly given that Elias, when questioned, disclosed the existence of the Perkins-Coie Fusion GPS contract, willfulness would be hard to prove. Well, after a year of questioning, when push came to shove, Perkins-Coie finally submitted a letter. But it is obvious this occurred after many people at the DNC and Hillary for America campaign either denied it or avoid answering it. And he provides a letter for them to look at. It appears it was due to legal action against Fusion GPS. That's why Mark Elias acknowledged it. It is not as black and white as someone asked Perkins-Coie and they came clean. But regardless, I want to compare it to the precedent from my own experience. I am the case agent for a FECA matter where an individual was questioned about a possible FECA violation by the press, and shortly thereafter that individual self-reported to the FEC. After that self-reporting occurred, the FBI was asked by the Public Integrity Section to open a full investigation into that FECA matter. Bullet point. How is that any different from once questioned PC publicly disclosed, or Perkins-Coie publicly disclosed that it had contracted with Fusion GPS? Another damn good question. Hopefully this answer will help me understand the standard for opening an FECA investigation better. 3. FECA rules, law, and disbursement reporting, and how that affects opening investigations. From the CLC complaint, the Commission's statement of policy states that, quote, the purpose of disbursement entry, when considered along with the identity of the disbursement recipient, must be sufficiently specific to make the purpose of the disbursement clear. And that, quote, as a rule of thumb, filers should consider the following question. Could a person not associated with the committee easily discern why the disbursement was made when reading the name of the recipient and the purpose? FEC statement of policy, purpose of disbursement entries for filings with the Commission, January, blah, blah, blah. The FEC has similarly advised candidates that, quote, the description must be sufficiently specific when considered within the context of the payee's identity to make the reason for the disbursement clear. Is this paragraph from the complaint accurate? If so, how can Fusion GPS's work have anything to do with legal services or compliance services? Said another way, how is Oppo Research legal or compliance services? This guy has damn good questions. Does the FEC approve of campaigns hiring law firms to then contract with third parties to provide any service? How do we know PC, Perkins-Coie, was not a purposeful pass-through? So many good questions. Is there a difference between direct concealment and concealment? Does the materiality of an ostensibly concealed disbursement affect prosecutor decisions on whether or not to open an investigation? I don't doubt there are reasonable answers to all my questions, And the answer is still, this is not a good candidate to open an FEC investigation. But I hope using this matter as a case study to ask questions will help me better understand the violation in general. This is a complex violation, and so far what is opened and what is declined makes very little sense to me, or very little consistent sense to me. Whatever I learn, I will be sure to share with our squad, so your energy will not be wasted just on me. Thanks, Redacted, Special Agent Redacted, FBI Washington Field Office. As I keep saying, this guy has some damn good questions. Do you think he's going to get damn good answers? Well, he gets an answer from Richard Pilger, or Pilger, 2 days later. No, it's exactly 24 hours later. Spot this. Spot this. June 18th, 2019, 4:04 p.m. Exactly 23 hours and 59 minutes later, Richard Pilger responds. He CCs someone else. Maybe it's Anna Lou at Fenton. I don't know. And he CCs Cooney. Okay. And he says, redacted. I think JP is correctly applying his discretion about the matter at hand for the specific reasons he spelled out the other day. Predication is the process point that you are focused upon, but it is not much different in this context than for other complex regulatory crimes under FBI operating procedures. It just has more sophisticated elements and sources of law, like the potential wild card of FEC action or deadlock on new theories implicating their regulatory authority, especially without very strong and unambiguous facts and open source material. The redacted predication you ask about under the redacted rubric was a Washington field office case initiated under the name redacted, and the relevant materials should be fully available to you. So he's saying that old case that we already suggested you look at, you should be able to go over and have access to. That charged case was a spinoff of a declination in part for the reasons JP applied to your matter, consistently with that matter, including the advice of counsel factor. Further, while that was a novel criminal case insofar as it focused on the expenditure side, the regulatory law was already well settled on the import of unambiguously false purposes reported to the FEC in open source evidence on the campaign's Form 3S, or Form 3s, I should say. So that'd be the false reports, where they claimed it was communications when it was something entirely different. And here, with Hillary Clinton campaign, they put down legal services for Perkins Coie, when in fact Perkins Coie had hired Fusion GPS to do opposition research. And publicly aired by a rival primary candidate in real time, we could see the payment for an endorsement falsely described as video or graphic services. I recently used the same standard for a certain charge that we successfully predicated, investigated, and took to a jury in United States v. Smuckler, Eastern District of PA, focusing on corruption in the congressional primaries that tend to determine outcomes in Philadelphia. As JP explained, we don't have that stable regulatory base and unambiguous factual predication for your matter. Taking a case off an administrative track at the FEC and into the criminal lane without unambiguously false and counseled reporting is a course that risks not only bad law in the criminal courts, but it also risks provoking half or more of the FEC into declining abatement and then effectively stopping us in our tracks with a deadlock or worse that would muddy our progress to date on the more strongly predicated cases. Like Aguilar, obstruction, and certain other cases, these expenditure cases tend to turn on magic words. In this context, the words of the Form 3. Please go to the FEC site and let us know what they are as to the purpose of expenditures. Your ECC has training to navigate the site. If it's facially a total lie, like catering, we can discuss further. If it's mushy, like consulting or legal services, I agree with JP that the regulatory law implicates an ambiguity as to the fact-gathering function inherent in those words, and that makes the predication unappealing. Pause. I I get it. Like, I think that makes sense as far as it goes. Right? Like, I think it makes sense as far as it goes. But what happens next in this email makes me think there's more to them turning this down than the mushy words. As the next two paragraphs, he says, the campaign finance case opening experience has plainly been frustrating for you, redacted, to an extent I haven't seen before. That appears to have triggered an extraordinary concern in your email below, which I have to address. I think you missed DC's point on the importance of Mark Elias evidence to an advice of counsel defense to willfulness, as opposed to some other kind of influence you suppose he could have, which would somehow create hills, cliffs, or other obstacles to us reviewing your predication without fear or favor. To my certain knowledge, no such influence exists, as one can see from how often and how recently the department has indicted that lawyer's clients in my lane. Nobody inside or outside the government scares me, redacted, and nobody gets any slack from me that isn't already present in the facts and law appropriately used to review predication. Nobody, ever. Please note, no consult with public integrity section is required of you when you take a matter to DC or the Eastern District of Virginia, which is why I left this to JP previously. The consult under the Justice Manual is then between PIN and the assigned attorneys, who may decline to open a matter or even consult me on any basis within their discretion, and in whom I currently have complete confidence. Regards, RCP. I think our plucky FBI agent, with all of his damn good questions and his metaphor of cliffs and hills, struck a nerve with Richard Pilger. Because that suddenly turned quite thorny, didn't it? And it didn't need to. What do you think happens next? June 21st, 2019, 9:55 a.m. 2 days later. Well, day and a half. Almost full 2 days later. Our special agent, ever intrepid as he is, writes back. Says, thanks for the response. This is actually really helpful. I apologize for being so dense, but I'm never going to be shy asking questions. And yes, the case opening experience with these matters is not clear to me. Also, my intent was not to get under your skin, nor was my Elias comment meant in the way you interpreted. Apologize. Lost in translation through the email. But I'm glad you're eager to fight the good fight when necessary and appropriate, no matter who it is against. Good job. You get a star, Pilger. So I can share with the others interested in the FECA case predication. I believe your salient points in the plainer language are: 1. Redacted. The facts prior to opening were compelling, and most of the facts JP mentioned were known at opening. Good case study in Sentinel. So he's saying the Sentinel is their own record system. So he's saying that he's looked at it. 2. Since the alleged concealment was by or through a law firm, the advice of counsel hurdle cannot be overcome. So we shouldn't try. That's a bit of a jab, guys. That's a bit of a jab. The way he's phrasing that. We shouldn't try. That's not how they would prefer it be phrased. 3. A disbursement to a law firm labeled as legal services or consulting, when it was really to a non-law firm vendor for opposition research by a foreign national, is too mushy, ambiguous. So it's unappealing, Pilger's word, to open in a hurdle that likely cannot be overcome. So we shouldn't try. Thanks for the guidance on Form 3s. I know the FEC site well and will look into the Form 3s, etc., and get back to you. 4. While FEC policy on disbursement reporting, as stated in the CLC complaint and pasted in my email below, seems pretty clear and unambiguous to someone like me. In truth, it's not clear, and it's very ambiguous. 5. By opening on this matter, since there was likely advice of counsel and the words are mushy, we would risk a bunch of bad legal stuff happening with the FEC, etc., as you describe it. That bad legal stuff seems pretty dire. I've been told the FEC basically does nothing about these, so are we really taking this off an administrative track? Thanks. Redacted. Guys, if you don't get it, this was a slap. Or as some folks would say, this is a clap back. Our intrepid special agent clapped back, and he clapped back real hard. It would be so great if somehow we had a recording of Richard Pilger's face while he was reading that response. So, about 40 minutes later, Richard Pilger responded to this. Said, redacted, the matter is not well predicated, and yes, I meant what I said about the FEC. This continued back and forth isn't what we do with line agents, and you are unique in doing it. In fact, we have written policy against it. At best, we are creating potential discovery in internal policy and deliberations. At worst, you are creating jinx on yourself. We might have to turn over in other matters to cross you for bias, rush to judgment, yada yada. If you remain dissatisfied, please have your special agent in charge call Anna Lou. And there we see Anna Lou right there. CRM. I think he got pissed. I think Richard Pilger got pissed. Next email. It doesn't tell us who it's from. It's redacted to redacted. But it says, got your message. I won't email him anymore. So that tells us that it's from the FBI whistleblower and our plucky, intrepid FBI agent who I've become a big fan of through just these few emails. It says, got your message. I won't email him anymore. On the 3 occasions where Rich has finally acknowledged my questions, his answers usually contain some veiled threat I believe is intended to have a chilling effect and stop me from asking questions. In my redacted years of being an agent, a successful agent with a great reputation, I have never been met with such suspicion or responses intended to have me go away. It is a confrontational and condescending attitude. In my job, I need to understand the violations, and if something doesn't make sense to me, I need to ask questions. I'm a worker, not a country club agent who is satisfied with unsatisfactory answers, and I'm not happy to go along to get along. The only possible jinx created in this email exchange is potentially his insinuation that I am biased or rushing to judgment, which could not be further from the truth and is actually him projecting. Bullet point 1, there's 3 bullet points here. In March, when discussing the HVF matter, he suggested I was picking on a politician, inferring it was a fishing expedition and trying to shut me down. You and I know it was not, and it was information I learned from my redacted case. Remember also that when pressed, he acted like he didn't know what the HVF was, which we know cannot be true. I would love to know what this HVF thing is. It's not the same thing as what he's messaging him about with Hillary for America. Something else. On June 19th, he emailed me after I asked perfectly reasonable questions to better understand this violation, and he seemed to take it personally and fire back at me in a tone that to some agents who are shy or newer agents with less experience would absolutely have stopped engaging and a reasonable exploration of how we predicated these cases. That chilling effect is shocking to me. Today, he shuts down all future reasonable conversation regarding my questions about predication and tries to demean me as a line agent and insinuates that I am biased and rushing to judgment, which could not be any farther from the truth. Between his insinuation and Jink's comment, he is creating a chilling effect. I am asking questions about a matter to learn from it, a matter he has already made clear isn't going to be opened. There is no jinx being created. This isn't even about a case that will be opened. It is trying to learn. I am shocked he wants to hide policy and try to shut me down, hide behind policy and try to shut me down with innuendo. Next Friday should be interesting. Wonder what's going on next Friday. Maybe they had a meeting with him about something else. I don't know. So these are the email exchanges we have. All right. But there's more. Because what this agent did was he went ahead and made an EC, an FBI electronic communication. And he made this on July 9th, 2019. So a couple weeks later, a few weeks later, he went ahead and created the document. And it's labeled as election law, zero file community watchdog groups, federal liaison, control file, sensitive investigative matter. Synopsis. To document redacted's request for a prosecutorial consultation supporting the opening of an FBI investigation into allegations that the DNC violated campaign finance law by falsely reporting disbursements to Fusion GPS. The U.S. Attorney's Office for D.C. and the Public Integrity Section's opinion is the matter is not predicated for a criminal investigation. Enclosed are the following items: the CLC complaint on the DNC, email correspondence, and then articles supporting concealment and a congressional letter. Writes, title, USADC and PIN prosecutorial consultation for investigation into DNC and Fusion GPS FEC violations. He lists the Form 3 records, Perkins Coie letter regarding Fusion GPS disbursements. Details. Prior to opening an investigation, while it is not required, it is common practice to obtain an opinion and prosecution commitment from a U.S. Attorney's Office. This is done for two main reasons. One, to prevent the FBI from devoting resources to a matter that will not be federally prosecuted. Two, to ensure the FBI is not pursuing a matter that is merely a technical or an ethical violation that will not be prosecuted. An initial prosecutorial opinion and commitment allow the FBI to develop an investigative plan directed toward proving identified elements of specific federal criminal statutes. Additionally, prosecutorial support and tools such as grand jury subpoenas are essential to effectively collect evidence and conduct a proper investigation. It is possible, if not common, to predicate election matter investigations solely on publicly available facts. Typically, journalists, or more likely a government watchdog group, will assemble fact patterns, sometimes in the form of official complaints to the FEC, DOJ, or FBI, which can then be verified by special agents. Once those facts are verified, a prosecutorial opinion is sought as described above. To that end, a publicized and well-known allegation against the DNC was articulated by the Campaign Legal Center, a well-known government watchdog, and provided to PIN and USADC, Richard Pilger, PIN Election Crimes Director, and Joseph J.P. Cooney, Chief of Public Corruption at the U.S. Attorney's Office for the District of Columbia. This was done in an effort to obtain a prosecutorial opinion. The official complaint from the CLC is attached digitally as a 1A. Prior to obtaining an informal consultation from the DOJ, the writer is the FBI agent writing this, believed it was reasonable to conclude that if the facts presented in the CLC complaint could be verified, this matter met the evidentiary threshold for opening an investigation into the allegation that the DNC falsely reported disbursements in violation of FECA, specifically because there was evidence of concealment. The CLC executive summary is Hillary for America and DNC failed to disclose that payment. It's from October 25th, 2017. CLC filed a complaint with the FEC alleging the Democratic National Committee and Hillary Clinton's 2016 campaign committee violated campaign finance law. They failed to accurately disclose the purpose and recipient of payments for the dossier of research alleging connections between then-candidate Donald Trump and Russia, effectively hiding these payments from public scrutiny, contrary to the requirements of federal law. In the email providing the official complaint to PIN and U.S. Attorney's Office, D.C., and requesting a prosecutorial consultation, the writer explained that it appears the facts support the unambiguous concealment of a disbursement, in this case, a very material disbursement, that'd be the payment to Fusion GPS for opposition research. Admin note, previously, PIN attorney Richard Pilger explained to the writer that in general it is important that a fact shows concealment before opening an FECA investigation. Concealment tends to suggest a possibility an investigation can prove willfulness. Attorneys, however, did not support the opening of an investigation, as can be read in the attached email. Specifically, Joseph Cooney states, quote, I do not, however, think this is a good candidate to open for a false reporting case. The FEC has approved campaigns hiring vendors, or in this case, a law firm, and that vendor contracting with third parties to provide services. Although I have not looked at the FEC report, any money paid to Fusion GPS for the dossier through PC Perkins Coie was probably reported as legal services or something like that, and he never looked at it. Although not typically what we think of as legal services, I think that we would have an exceedingly difficult time proving it was willfully false report. That is particularly so given that Elias, when questioned, disclosed the existence of the Fusion GPS contract with Perkins Coie. After receiving that opinion, the FBI, specifically redacted, will not seek to open an investigation or an assessment. The complete record of emails involving this request for a prosecutorial opinion is attached. So, how you like them apples, Mr. Pilger? How you like them apples? Now all of this is with the Judiciary Committee in the Senate. And let's see if AG Bondi or Director Patel turn over any other documents related to this. By the way, Richard Pilger's name might be a bit familiar to you guys. He's one of the people involved in the opening of the Arctic Frost investigation. So it seems he has a history of turning down investigations into the Clintons and approving investigations into people in Trump's world, including Trump himself. Funny that. Okay, I'm back, and this segment's kind of a one. It won't be that long, maybe like 10, 20 minutes or so, which probably means 30. If I'm imagining it's going to be 10 to 15 minutes, it's probably going to take 30 minutes, right? I want to revisit the early days of the Russiagate scandal and keep the previous segment in mind with the emails and the Washington field office and Fusion GPS and all that stuff. Keep that in mind. So I want to go back and I want us to think back to 2016. And what I want to do is present to you a bit of a new perspective. I guess it's not really that new. It's kind of an evolution of, it's an evolution of some of my thinking on it. So a lot of what I'm about to say isn't entirely new, but I've never said it in the way I'm about to say it. And the origin of this, what's going on, and the reason I want to revisit Russiagate and its beginnings, and ask you to reconsider maybe what you think about it, and especially consider what media has led you to believe, is because I went over this thread earlier this past week. It's a really good thread from Eric Garland. And it's back from 2022, February of 2022. So it was while Durham was still active. And I went through and read this whole thread, and it took me back to those days. And he has his own way of presenting these things that reminded me of some key pieces of info that aren't always highlighted on the right in right-wing media, because they don't necessarily serve the I'm trying to temper what I want to say, the narrative that the right-wing media wants to put forth, okay? But I read through this thread of his, and I'm not going to reread the whole thing now, but I want to take you back to the beginnings of Durham, and I want you to consider that Durham ran from very early on in the investigation. Remember, he's part of the media leak investigations we were talking about earlier in this episode. And what did those leaks have to do? They had to do with, just grab our chart that we've been using. These media leak investigations are all tied to Russiagate, or almost all of them are. They have to do with the Dutch intelligence that got leaked out, the Renteria memo, the Flynn Kislyak call that leaked out, the Carter Page FISA's leaking, the analysis by the U.S. intelligence community that Putin directed Russian hacking, which wasn't even a real thing. It's conjecture. And it's that well, it's true that Russia and Putin did direct influence operations into the 2016 election, and that they hacked individuals in the 2016 election. What's not true, and what is a load of horse manure, is that Putin preferred Trump to win. And yet media has made so much out of a baseless allegation, a baseless conclusion from the 2017 ICA, that's what was happening. It all goes back to the Steele Dossier, right? And then the secret email channel between Trump and Alpha Bank and the Trump organization, and all of that, and the Kushner Kislyak back channel. So, and then all the stuff that Adam Schiff was leaking through the HPSCI and the staffers that were running over to the CIA and reading intelligence reports. Durham was involved in this, as were others, trying to trace the source of these leaks, because these leaks ultimately mischaracterized what the FBI was working on and why, who the targets were and why. And I've talked many times on this show about how it's a lie that the FBI was after Trump, that Mueller was after Trump, that Strzok and Page and Comey were after Trump. It's all a lie that the media created. And they created it because it was useful to them. It was useful to the left because they wanted to damage Trump's presidency and the way it was viewed, and the way people thought of it, because perception is reality, and we're in this information/narrative war now. And it's 24/7. It's part of 5th generation warfare. We've talked about that many times, and I have my article on it right here, The Invisible War. And it doesn't matter whether you want to be a part of it or not, you are. It doesn't matter if you're interested in the information war. The information war is interested in you. And we're constantly being influenced by these things. And that includes, most especially, media reporting. Whether you think their reporting is BS or not, I tend to find that people who dismiss all of legacy and mainstream media reporting tend to embrace all the right-wing media reporting. And both are fake news. Both traffic and make money and persuade their audience with the same fake news. It's just different angles of it. And so the media, the legacy media, the left-wing media, they're trying to turn their audience against Trump and the Trump admin. The right-wing media is trying to turn you against the FBI and the DOJ. And the net effect of it is that you don't know what to believe, or you end up believing some of the wrong things. You get misimpressions, and then it ends up, I talked about your filter that you need. That was one of my main points at the conclusion of this article, is that you have to develop a filter to filter information through. You have to develop discernment, and you have to constantly be checking your conclusions and being open to changing your mind. And that it's like a exercise regimen you can't step away from. You have to keep up on it, or else you're going to start atrophying those aspects of your cognition. And these, whether it's an outlet or an influencer on the left or the right, they're going to end up corrupting the way you think about things. And the way you avoid that is to constantly be thinking about them and being open to critical thinking. I meet so many people, or I come across so many people online who will throw out critical thinking, like, I'm a critical thinker, or they'll talk about how the other side doesn't know how to think critically. And it tends to be the people that bring that up the most are themselves some of the most biased and non-critical thinking people. Because to think critically means to be willing to re-examine what you believe and to be able to stack it back up, to disassemble what you believe about a thing and then be able to piece it back together, and for it to make sense, for there to be a structure to it. And that when something adverse to it comes in, you don't just flick it away. You measure it against what you already know. And where there's contradictions, you understand that there's no such thing as a contradiction. There's no such thing as a contradiction. And wherever you find a contradiction, you have to check your premises, right? So back to this thread. I was going through this thread and I was reminded of the early days of Crossfire Hurricane and the early days of the Durham investigation. And I was thinking about some of the things that seem like contradictions. And one of the ones I pointed out to you before is that Christopher Steele was a very, very experienced intelligence officer for the UK. He was a leading intelligence officer with an expertise in Russian operations. He had the knowledge, he had the skill set, the know-how, he had the reputation of someone who did good intel work. And yet he brings us the Steele Dossier, as it's known, which is poor intel work. It's rumors at best. It's made up stories, third-hand stories. It's old accusations against the Bidens repurposed into accusations against Trump. It's a piece of opposition research that he was paid to put together. He relied on Danchenko, a Russian intelligence officer himself, and Chuck Dolan, a Democrat operative, and made up these stories about PP tapes in the hotel room and all of this other junk. And Christopher Steele, who was also a confidential human source for the FBI for a time, brought this junk to the FBI and concealed that it was paid for by Trump's opponent. And then you have people who know damn well what they're doing in the FBI. Comey knows what the hell he's doing. Comey's been at the FBI for years and years. Before he was FBI director, he was deputy attorney general. He was very well respected. His reputation was very good. And before that, he was a mafia prosecutor in the 80s and 90s alongside Rudy and Ray and Terwilliger and so many others that we're very familiar with. And then you have Peter Strzok, who is head of counterintelligence operation, very experienced, very well regarded, very intelligent person. And this Crossfire Hurricane thing begins, and it seems in retrospect like all of these people who knew better made these missteps and somehow got taken for a ride and created Crossfire Hurricane. Then it rolled into the Mueller investigation, and somehow they fell for these lies that Trump was colluding with Russia. And I don't think that's what happened. And when I go back and look at the timeline of these investigations, and when I look at Barr and what Barr did to investigate these things, and I look at Durham and him bringing in Durham and then elevating him to special counsel, and then Merrick Garland keeping Durham and letting Durham finish his investigation, take it as far as he could. And I look at what the Clinton team did and Clinton associates did to try and keep the investigation going, to continue damaging Trump into his presidency. And I tried in the media. I don't think the official story, the way it's told on the left, makes a lot of sense. And I don't think the way the story of Russiagate is told on the right makes a lot of sense either. On the left, they tell the story as Trump and Russia did collude. Putin helped Trump win 2016. Comey sabotaged Hillary Clinton because he didn't close down the email investigation soon enough, number one. And then two, he reopened it on the eve of the election. And then WikiLeaks sabotaged Hillary Clinton with the emails that they got from Russia. And it was all to the benefit of Trump. And there's definitely Trump-Russia collusion. He has all these businesses with the Russians and all these different things, right? Which, it's true. There's a number of connections between Trump and Russia, a bunch of them. And a lot of them have to do with real estate. And yet the Steele Dossier, the opposition research on Trump that had to do with Russians, the actual connections between Trump and Russians, completely left out of the Steele Dossier. And that's one thing that's always like, what? How could they put together a dossier on Trump-Russia collusion and look at all these media reports on Trump-Russia collusion, yet they leave out some of his actual real estate dealings with the Russians? Why are they blind to that? And then on the right tells the story of Trump-Russia collusion and Russiagate as being completely false. The FBI and the DOJ are just big, bad institutions that had it out for Trump. They tried to sabotage his presidency. They were always investigating him, looking for evidence of a crime so they could indict the president. They wanted to take out all of his friends. They made up all of this stuff. And if they couldn't find a crime, they punished them with the process. They went after Stone and Cohen and Flynn and all these people, and Manafort, and the right is like blind to so many of the things, just like the left is blind to so many aspects of it. It's like each is not just looking at it with one eye blind. They're just only looking over in a direction of it. They just want to see this one piece of the whole story. And it's neither one comes up with a coherent explanation for all of it to where it all fits. And you guys know I read all the Durham stuff, and I've been on this for years. And we would come across these contradictions and these, why is this why is this person trying to do this thing, like the Steele Dossier or the Alpha Bank hoax, or Jaffe and his fabricated DNS lookups and connections. And then you have these people in the FBI. It's like, why are they falling for this obviously garbage predicates for an investigation, a bar conversation between Papadopoulos and Halper? How does that lead to Crossfire Hurricane and a FISA on Papadopoulos and Carter Page? And then you have the FBI attorney Kleinsmith obscuring from the FISA team, or the team that was getting the FISA and the renewals for it, not informing them that Carter Page is a CIA asset whose job it is to gather intel on the Russians. So of course he has connections to the Russians. And that right there is made up like, okay, this one guy in the FBI engaged in this criminality, got a slap on the wrist for it. Therefore, the right-wing media extracts that the entire FBI and DOJ is corrupt and they're all after Trump. They need to be destroyed. And on the left wing, they find one connection between someone in Trump world and Russia. Oh, Kislyak spoke on the phone to Flynn before Trump was sworn in. Or Kushner and Kislyak had a meeting at Trump Tower or wherever it was. And Sessions also ended up showing up. Therefore, that's Trump-Russia collusion, right? They completely ignore all of these things, how weak it is. They completely ignore how weak it is. And they definitely ignore all of the Democrats and Clinton's connections to it. They completely pretend like Chuck Dolan does not exist. Rodney Jaffe does not exist. They completely ignore that Steele's subsource was Danchenko, an actual Russian intelligence officer. And they completely ignore the possibility that maybe he fed a bunch of horse manure to Steele. So anyway, I reread this thread. It's a couple years old, from Eric Garland, who's a great follow, by the way. And I just kind of had this little brainstorm thing come up. And I wanted to read it to you guys. I want to toss it to you as a reframe, or maybe even a reintroduction to Russiagate. And I also want to encourage you to go back and either read his thread or read some other old Spygate stuff from back in 2016 or 2020. You know, we've had a lot of disclosure since then. And it's interesting to go back over that material from the earlier days and have the benefit of fresh eyes, have the disclosure that we have now, especially with the Durham report and the IG Horowitz reports. And you notice that did IG Horowitz find anybody in FBI or DOJ that acted politically corruptly to influence the investigation? No. And of course, right-wing media says, therefore, Horowitz is corrupt too. Everyone I don't like is corrupt. Everyone who doesn't say something that I already believe is corrupt. That's the angle of the right-wing media so often. And on the left, it's the same thing, just a mirror of it, right? Okay, so I had some thoughts after a refresh, a trip down memory lane. And I just want to present to you the possibility that perhaps Team Clinton planted the Steele Dossier and its associated controversies, the P-tape allegation, the back channel allegation between Kislyak and Kushner, the back channel between Flynn and Kislyak, all the stuff that was in Steele Dossier, the Alpha Bank hoax, all those things. Perhaps Team Clinton planted all of that to lure the FBI into a bear trap. One that would force the Bureau to chew its own leg off in order to get out of it, such as by firing Comey and a few others so that they could promote McCabe, who did what? What did McCabe do? McCabe protected the Clinton Foundation, and McCabe protected Hillary Clinton in the laptop investigation. McCabe leaked to media and got caught. Why would the FBI fall for such a trap? Well, what was the FBI going through in 2016? They were investigating Hillary Clinton, both the email server, which was known, but also her foundation, which wasn't publicly known for a time. And so the FBI was under Comey has talked about this, the FBI was under a ton of pressure because they were investigating the former head of the State Department, and they were investigating the current lead Democrat nominee and the expected winner of that election. Everybody believed that Hillary Clinton was probably going to win. And she almost did, right? So it wasn't an unjust expectation. It wasn't an unjustified expectation. And Clinton was pretty pissed off that the FBI was looking at her, right? Do you think that after she won, she was going to keep the people who had just investigated her server and her foundation? Do you think she was going to be interested in keeping them in the FBI and in the DOJ? She needed a way to get rid of them. But if she won and those investigations weren't complete, or if there was something about their closure that looked odd, and then she fired those people, that would be its own scandal, wouldn't it? She needed a way to damage the FBI, to damage their credibility. What did Comey talk about in the very hearing that he's now been indicted over allegedly lying in? His opening statement was about the pressure the FBI was in and how they needed, about credibility. Why did he make the announcement himself on the closing of the email server? Because he didn't believe the DOJ had the credibility. Why did they not have the credibility? Because of Loretta Lynch meeting with Bill Clinton on the tarmac. Because of what was in the Renteria memo. That hacked emails showed that Loretta Lynch had assured Hillary Clinton's campaign that she wouldn't let the investigation into the email server go too far. What if what's going on that led to Crossfire Hurricane, that led to Russiagate, what if the whole purpose of the Steele Dossier and all the related stuff was to create a bear trap for the FBI, one that they would step into because they would feel like they had to do their due diligence? Well, we got all these allegations. We've just been investigating Clinton. We can't now not investigate the Trump campaign when we have Christopher Steele, a highly credible, at the time, British intelligence officer who's an expert on Russia, who brings us all these allegations and these reports that he has from his sources in Russia telling us that Trump and Putin have secret back channels and they're communicating, and there's this, the media hasn't fully unearthed the gravity of the relationship between Trump and Putin. And it would end up being a trap because it would turn out to be horse manure. And it would damage the FBI's credibility. It would make the FBI, and by extension DOJ, look like they had just interfered in an election, one on against Clinton, and then two against Trump. And Clinton was going to show up, and she would fire Comey, and she would promote McCabe, who, what did McCabe do in that Wall Street Journal article? That Wall Street Journal article I read to you, I don't remember what I have it bookmarked under. I don't remember what happened. The one, we've gone over it several times recently. The one where he portrayed himself as being the arbiter of what was just in the FBI, and how he got out of the email and the foundation investigation because he's a stand-up guy. And he cares so much about justice and about ethics and doing the right thing. That article that he leaked to all that information he leaked to the Wall Street Journal through Lisa Page, that Horowitz later busted him up for. He did that to make himself look good ahead of the election when Hillary was going to win. He wanted to make sure he looked like the best possible pick for the next FBI director. That was the point of leaking that. That was the game plan. He was setting himself up to be the next FBI director. And think about all of the ink that has been spilled by right-wing media going after Comey over FISAs, over Steele Dossier, over Crossfire Hurricane, over leaks. They ate it up because they wanted him gone, because what had he done? Comey had just investigated the email server and the foundation. Right-wing media goes after him, and left-wing media goes after Comey. It's particularly during 2016 and right after. And then he gets rehabbed a bit when Trump fires him, because the media want him to dish on Trump. The media want him to talk bad about Trump. Right? Now, take yourself back to 2016. Nobody thought she would lose. So think about that. What's the purpose of the dossier if they don't think Trump's going to lose? If they don't believe he's going to lose, why even bother with this opposition research junk? Well, because he wasn't the target. The FBI was the target. In the Clinton campaign, they didn't believe the email server investigation would go too far, did they? So they didn't do this to try and undermine that probe. They knew they had assurances from Loretta Lynch that she would not let the email investigation go too far. But the non-public Clinton Foundation investigation was running concurrently across 3 field offices. Later, it became 4 FBI field offices, because Los Angeles came in December 2016 after they got Shagari, billion-dollar donor to the Clinton Foundation. I've talked about his indictment and his plea deal before. And how what they got from him kind of, we don't know exactly what it did, but it seems to have taken the Clinton Foundation probe to a new level. And McCabe, he repeatedly interfered in the Clinton Foundation probe investigation. Even after he recused himself and claimed to media that he had recused, he kept interfering in it. Remember, he joined that secure video teleconference call he wasn't supposed to be on and had to be told to leave? Late October 2016, McCabe leaks to the Wall Street Journal via Elisa Page about both Clinton investigations and portrays himself as some kind of hero. That he was a real stickler for the rule of law and the pursuit of justice, and then he recuses himself from the Clinton Foundation investigation. I think he trusted it would be closed, that no one was going to pick it up because he trusted she was going to win. And the DOJ wouldn't let it be picked up because of Loretta Lynch. And then because the public would know he had recused, and the public would know how he was over the email server investigation, and that ended up closing. They didn't find a crime or no reasonable prosecutor, blah, blah, blah. And he trusted that Clinton was going to fire Comey. And he also trusted that the FBI was going to go through a bit of a crisis because of the Steele Dossier being something they never should have accepted. They never should have gone off of. And he was going to blame Comey for it. Comey was going to be made to fall on the sword, if possible, or just fired. And then McCabe would be left there as the man to inherit the office. But Trump wins. And now what do they do? Now what do they do with all this stuff they just planted? Well, FBI gets Danchenko in January 2017, and actually before that, December, what do we now know happened? Obama, Clapper, Brennan, they have the ICA, and they say it's not good enough. It doesn't have the narrative they want. Comey pulls the FBI out of the ICA, says, no, we're not there on those conclusions. NSA is saying, no, we're not there on these conclusions that Brennan and Clapper are going for. But then they bring McCabe into the meeting, and McCabe's like, yeah, FBI will sign on to that. Brennan shoves Steele Dossier, a summary of it, that allows for the conclusion that Putin preferred Trump. Guys, they doubled down on their bear trap. They decided the only way out was through, in a way. And they decided we got to make sure this bear trap, we're just going to increase the bear trap. We're just going to make the trap that much bigger and that much meaner. Because we can't. Trump's going to come in. And we got to make sure that now he feels like he can't maneuver in the way he needs to. So we got to do something. We got to blow this thing up too big for him to deal with. And so 2017 Steele Dossier, or 2017 ICA, helps feed that scandal, the leaks, all these leaks to media. The Flynn Kislyak call leaks in late December 2016, which then allows for the media to report that already Flynn was going behind Trump's back and colluding with the Russians, or maybe it wasn't behind Trump's back. Maybe this is one part of their secret agreement. They got FISA's on Carter Page. The U.S. intelligence community analysis leaks in December to NBC News. And so ahead of the 2017 ICA, the media is already reporting on what the conclusions are supposed to be of the 2017 ICA. And then Sussman, who went to the FBI with his Alpha Bank garbage, and the FBI didn't quite bite on it. They looked at it, but the analysts were like, this doesn't make sense. Because Jaffe and the Georgia Tech researchers, they didn't do a good enough job cooking up the data. So Sussman decides, well, I already got shut down on presenting that, but I got to keep pushing. So what does he do? He goes to the CIA in what was it, March or April or February of 2017 to try and get them to start looking at it. Not giving up. They just keep pushing it. And then in January 2017, the FBI gets Danchenko, and they realize he's likely a GRU officer or something similar to that. And they're like, okay, we gotta extract from this guy all the intel we can, because he's actually could be a really good source for us. And he ended up being a treasure of information about Russian intelligence operations. They also realize he's Steele's subsource. And so that kind of adds to the credibility of the Steele allegations, because they're like, well, this guy's actually probably a GRU officer, and he knows all this other Russian stuff about Russian operations, and that checks out. Personally, folks, I think Christopher Steele scapegoated Danchenko. I think Christopher Steele's real source was Chuck Dolan. But by making the FBI believe that his source was Danchenko, and knowing that Danchenko really was a source of intel on Russian operations, it would make the Steele allegations look a bit better, right? I think that setup was to distract from Dolan being the source. I also don't think that Sergei Millian is pure as the wind-driven snow. I think that was something that was supposed to develop a little bit more and didn't, and they had to cut it off. And now Sergei Millian plays victim. So post-Clinton losing, the FBI's leg is already in the bear trap. Already in the bear trap. So what they decided to do, the people that were complicit in this scheme, decided they got to make sure that bear trap shuts and stays shut on the FBI's leg until the FBI chews it off. Media keeps doing what they do on both sides, which does what? It helps Hillary Clinton. The media on the left keeps on pushing her narrative of Trump-Russia collusion and trying to delegitimize Trump's first admin, trying to rehab Hillary, ignoring all of the problems with the allegations. Media on the right keep on blaming the FBI and accusing the FBI of going after Trump when they weren't. Because I don't think the FBI leadership, I don't think they ever really believed that Trump was the bad guy. I don't think they ever really bought into this. I don't think they ever fully bought into the Dossier allegations. If they had fully bought into it, then why did they pull out of the 2017 ICA initially? Why did Comey initially say, we're out of this? Those aren't they're the ones who had the Steele Dossier. The FBI did. They were still investigating it, and they were like, this isn't up to snuff. But they took out the FISA on Carter Page because Kleinsmith concealed that Page was actually CIA. Like, well, this guy does have Russian connections. And there were people around Trump's campaign that had connections to the Russians. So there was enough there to predicate some investigation. But they weren't looking at Trump connections to the Russians. They were looking at Trump campaign personnel's connection to various Russians. And then what do we get? We get years of investigations within investigations and investigations into investigations. Politicians and media engage in a narrative war, and that narrative war keeps the public from fully appreciating the nuance and the dangers of all of this, which is dangers to the legitimacy of a president, dangers to the legitimacy of the DOJ and credibility of the DOJ, and dangers to the legitimacy and credibility of the FBI. Which advantages who? The swamp. And why, again, revisiting why Hillary Clinton believes she's going to win. Media believes she's going to win. Everybody thinks Hillary's going to win. Why would she need to set such a trap? Because the Clinton Foundation investigation. Because it was running concurrently with the email one. McCabe was interfering in it because he was worried about it. It was way more of a threat to her and Bill. And late 2016, they're looking for these 3 FBI offices that are involved here: New York, Washington, and Little Rock. They're looking for a U.S. attorney's office that's willing to send subpoenas and go through the next steps, because they've got predicates for investigation. They've got enough to keep it going. And then LA comes in. Late 2016, the LA field office gets Gilbert Chowdhury, and they learn a lot more about foreign contributions to the Clinton Foundation. In January of 2017, the New York field office, Washington field office, Los Angeles field office, and Little Rock each briefed their respective holdings, meaning their evidence, everything they had in the case. They briefed it to Comey, to others in DOJ and FBI. The New York office advised the FBI that they did not have a U.S. attorney willing to work the case and provide subpoenas. Little Rock briefed that they did, that their U.S. attorney was willing to work the case. When you go to this Clinton Foundation timeline that we got declassed this summer, which stamped CID, but it's also stamped FBI DOJ-OIG. So Horowitz had this. Don't know why, but when you go to the bottom here, it says that was on January 11th, they did that briefing between all 4 field offices. Little Rock said they're willing. 6 days later, redacted sent an email to New York field office, Washington field office, Little Rock, and CID advising that following a meeting with redacted, a decision had been made to assign FBI redacted to conduct a 30-day in-depth review of the Clinton Foundation investigation. 3 months later, it was supposed to be a 30-day in-depth review. 3 months later, April 10th, redacted was briefed on the Clinton Foundation investigation. Redacted, CID, Washington field office, New York office, and Little Rock participated in the briefing. July 7th, 2017, a meeting was hosted by Redacted to discuss a way forward. Redacted, CID, Washington field office, New York office, Little Rock, and OGC participated in the briefing. 2 weeks later, Little Rock Redacted spoke with the Eastern District of Arkansas, U.S. Attorney's Office, redacted. Supervisory Special Agent Redacted also separately spoke with Eastern District of Arkansas, redacted. Eastern District of Arkansas was supportive and agreed, redacted, but would require DOJ concurrence before moving forward. This is middle of 2017. August 2nd, 2017, redacted and redacted met with DOJ criminal divisions, redacted, and redacted. So much is redacted from this area right here. Something happened. SC redacted and UC redacted from CID and redacted met separately with redacted PIN, public integrity. Redacted and PIN redacted to discuss the Clinton Foundation investigation. What do you want to bet one of those is Pilger, who we were just talking about in that email thread? During both meetings, DOJ personnel indicated U.S. attorneys have the autonomy and discretion to pursue any investigation deemed appropriate, and Eastern District of Arkansas does not require DOJ concurrence to move forward. After discussions between Little Rock redacted and SC redacted regarding CID's 8-2 meeting, so again, something happened here. Something significant is under these redactions. The meetings with DOJ that day. Redacted called Eastern District of Arkansas redacted to determine if they had heard from DOJ about DOJ's position on the matter. That Eastern District of Arkansas does not need concurrence from DOJ to proceed. Redacted stated that he had not heard from DOJ, but would call them to see if that was true. Redacted added they continue to fully support Little Rock FBI on this matter, the Clinton Foundation investigation, and reiterated it was, quote, the right thing to do, since the allegations were like any other probable cause case. Actually, I don't know if that's supposed to be probable cause in this instance or public corruption. I'm not sure. That would be worked, albeit this matter was more sensitive than others. However, because DOJ had told them to stand down last year, Redacted was going to wait until DOJ gave them concurrence to proceed. It is unknown if Redacted had contacted DOJ. 2 weeks later, 12 days later, SC Redacted CID received a telephone call from Redacted who requested follow-up information concerning the 19 Clinton Foundation bank accounts obtained by the LA field office during a separate campaign finance fraud investigation. That's Gilbert Chowdhury and Thornberry, Mac Thornberry, I believe. He also requested a copy of the Redacted, and then we got a big redaction block, and that's where this ends. We don't know if there's another page to it. We don't know why this timeline was produced. But when I think about that, what we just looked at with that email thread and Richard Pilger and the other guy's name just blew out, this is Cooney, icing that Clinton investigation into payment for the Steele Dossier. That's happening in that same summer that this is going on, and Little Rock is saying, we're ready. We're ready. We just want the go-ahead from DOJ because we were already told that we didn't have DOJ support before. But now we're being told by others that we do have DOJ support, so we just want DOJ to say, yes, you have our support because this is sensitive. Did this also get iced by those same guys? Also at this time, Comey's been fired, and who's the acting director of FBI? McCabe. It's in August that Christopher Wray, I believe it's August that Christopher Wray comes in. So after this happened, did this ever proceed? Did the effect, did this bear trap set by Team Clinton in the media, Team Clinton in the FBI and DOJ, Team Clinton, the campaign, Team Clinton, the politicians, Team Swamp. Did they manage to put the FBI in a position where they felt like they couldn't go forward on this? interested to hear you guys' thoughts. This timeline was created for a reason, and we don't know why. The date right here says October 17, 2017, but it goes beyond. It goes to right there. So it doesn't quite reach October 17th, 2017, does it? Dead there, right there. It doesn't quite go all the way to October. So I feel like there's one more page of this. And I may be wrong, because this little gold line doesn't keep going, right? But I feel like there's another, even if there's not another time slot, like another bullet point with a date, I feel like this page goes on. There's another page to this. We have 6 pages of it so far. Also, I don't know. I guess my picture's in the way. Let me take down here. It says FBI, DOJ, OIG, ELEC, which to me makes me think election. So it makes me wonder if this was produced for Durham as part of an investigation into election interference in 2016. Don't know. But the more, this little trip for me, this trip back through the early days of Durham and of Crossfire Hurricane, it just makes me, I'm pretty firmly in this opinion that Team Clinton was, their goal was to not damage Trump. Their goal was to damage the FBI. But media made it about damaging Trump, and it needed to be that after she lost. And then right-wing media joins them in making it about the FBI. Because in truth, swamp creatures will always join in on anything that weakens the FBI. Swamp creatures are all about that, aren't they? All right. Thank you for tuning in for this episode. I said I would go 30 minutes. I ended up going an hour. It's almost like I had a lot more to say than I thought. Guess I've been saving it up. Okay, on the next episode, I'm sure we'll have more Comey updates. But I also had covered for you guys in this short video on Trump designating 4 European Antifa groups as foreign terrorist organizations. I mentioned the United States v. Arnold case. And I said that I read to you guys a filing in it where the U.S. attorney in this had said they were about to bring a superseding indictment after they were securing some plea agreements with some of the defendants. And there's like 15 defendants in this case. Well, it arrived. November 13th, a superseding indictment was filed. So, and that, I told you that I would present that indictment to you. This is a first of its kind case against members of an Antifa cell. And it looks like there were 15 defendants. Now there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. So it would appear that 5 people have rolled. And now we have these 10 defendants. Actually, it counts them as 9 defendants right here, doesn't it? Did I miscount 1? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. I count 10 defendants. Who is it skipping? Looks like it skips the last guy, Sanchez Estrada. Maybe Daniel Rolando Sanchez Estrada. Oh, okay, he just has an extra long name, so it's 9. 9 defendants. That means they got 5 or 6 people to roll. Maybe they'll be cooperating witnesses against these. So the 2 guys, Arnold and Evans, are the supposed members of an Antifa cell in North Texas. So I'm going to go over this indictment with you on a future episode coming up this week. and we're going to be tracking this case to see how it goes with what investigative tools the FBI is able to use to go after this cell, and this may develop into going after some more. I'm not going to pay as close attention to it as I do the Comey case, but we are going to track it. And then it was big news last week and the week before that the Blaze had ID'd supposedly the January 6th pipe bomber. And I was very skeptical of this, extremely skeptical of this story. And I think it's just blown up in the Blaze's face. I think the Blaze have really screwed up. I think they've screwed up big time. And they're going to get sued big time. But I know this was a big story, especially in right-wing media. And I had prepared a presentation on it. But I wanted to give it my due diligence, and then I want to take my time and give it my due diligence to give it a fair shake. I wanted to see what this woman said in response to it, which she now has responded through her attorney, who I think is going to be filing lawsuits against Blaze. But in the process of going over this, it felt like a good occasion for me to talk about January 6th. And so I want to make sure I have enough time to do that. So anyway, we're going to get to that on a future episode. All right. Thank you all very much for being here. And thank you for hitting like and for sharing the episodes. Thank you for all your support. Really appreciate it. Y'all stay positive, stay blessed. Remember that we're all just human. So treat each other's right. And I'll see you in the next one.